अब नाम चेंज करना पड़ेगा बाद में। चलो, okay. Good morning, guys. Yesterday, a lot of glitch problem was there. Somebody amongst you was praying. Today's lecture should not happen. God accepted your prayers. Okay. Let's see. Now, beta, yesterday we completed with mixed delivery. Yes. Sir, in case short delivery takes place, mixed excess delivery, mixed delivery, what are the options for the buyer? Okay. Next is buyer's right to examine the goods. Very simple. Sir, whenever you do online shopping, when the goods come to you, is it your right to check the goods or not? Answer is yes, you have a right to examine the goods. Whether the goods which you ordered, okay, and the goods which we came, okay, are in alignment, yes or no? That is section 41. Very simple. Okay. Next, acceptance of delivery of goods. What does that mean? Sir, we studied beta, it is the duty of the seller to deliver the goods and duty of buyer to accept the goods and pay for them. So, sir, when can we say that the buyer has accepted the goods? Okay, accepted the delivery of goods. Three things happens beta. It is deemed that he has accepted delivery of goods. Which are the three things? Section 42, acceptance is deemed to take place when buyer intimates seller that he has accepted the goods. First, informs I accepted. Does any act to the goods which is inconsistent with the ownership of the seller, resells the goods or pledges the goods, only owner can do. That means he has accepted the goods. Retains the goods after a lapse of reasonable time, okay, or after specified time. As I told, if I deliver the goods, if you don't like the goods, you intimate me within 10 days. Without intimating me, beta, you kept the goods, beta, for more than 10 days. It is as good as you have accepted the goods. Am I clear? Next, buyer not bound to return rejected goods. Section 43. Tell me, whenever do you online shopping and in case whatever the goods come, okay, products come and you don't like it, okay, example, you ordered from Amazon, so you yourself go to Amazon office and give the goods back? No. What you do, just better you call the call center, okay, helpline number, and tell me I'm rejecting. Okay, yes or no? Or on the app only you do it. Same thing, section 43. Okay, it is not the duty of the buyer to return the goods, just to intimate the seller. Am I clear? Unless otherwise agreed, where goods are delivered to buyer and he refuses to accept them, having the right so to do, he is not bound to return them to the seller, but it is sufficient if he intimates to the seller that he refuses to accept them. Am I clear with this thing? Understood? Next, liability of buyer for neglecting or refusing delivery of goods. Section 44. What does that mean? For example, we ordered some goods from A. Now A told B that, sir, I have to bring it from USA. Transportation charges will be 10,000. Okay. Then I'll intimate you. I'll keep it in the godown. My godown charges 500 rupees per day. Okay, I'll intimate you. You come and take it. A informed B. B is not coming. It's been 10 days he did not come. Now tell me, it is as good as he is not taking the delivery. Now can A recover 10,000 plus 500 into 10 days, 5,000, total 15,000 from B? Answer is yes. Which section tells that? Section 44. The buyer, if he doesn't take the goods, he is liable to the seller for any loss occasioned by his neglect or refusal to take delivery. Any loss, your transportation charges and all. And also for reasonable charge for the care and custody of goods, 500 rupees per day. Am I clear? Yes? Okay. So that is the point. Okay. This is where beta unit 3 comes to an end. Now we'll be doing beta unit 4. Let's start. Okay, I hope you understood unit 3 properly. Yesterday I was about to finish unit 3 and finish unit 4 also. But okay, luck was not in our side. No problem. Okay. See, now the next unit is unpaid seller. Now in this unit we'll be studying who is the unpaid seller, what are his rights. Then basically one section is there, okay, section 53, effect of pledge or subsell. Then we'll be studying rights of buyer against seller, and last auction sales. All these things we'll be studying under sale of goods act. Okay, let us understand what is this. Okay, so see, unpaid seller means what? But an unpaid seller means a person who has entered into contract of sale, but he has not received his, means he has either done sale or agreement to sell, but he has not received his whole consideration, whole payment, okay, on the agreed date. So he is unpaid. Now 100 rupees का goods है, okay, even if he received 99, 1 rupee he has not received, so he is an unpaid seller. Am I clear? And he will be having rights, okay, on the goods as well as on the buyer. So see, unpaid seller means a person who has sold his goods, but whole consideration is not received, or he has received some bill of exchange or negotiable instrument and the same is dishonored. Now he will be having rights against whom? Against goods and against buyer. Now against goods, what are his rights? But against goods, his rights depends upon whether the ownership is transferred, means he has done a sale, or ownership is not transferred, he has done agreement to sell. Okay. Now if ownership is transferred, he has three rights: right of lien, right of stoppage in transit, and right of resale. When ownership is not transferred, he has his right to withhold delivery and other rights of owner. Okay, so let's understand one by one. Right of lien. Lien means beta what? Right to retain possession of goods of another. Right to retain possession of goods of another. Why another? Because here who's the owner? Buyer is the owner. Seller has given the ownership. Okay. So sir, when can this right be exercised? This right can be exercised in case of fulfillment of some condition. First beta, okay, example, I sold goods to Mr. X today, okay, and I told you it is for cash and 100 rupees is the price. He gave 19, is like, sir, 10 rupees I'll give it to you, I'll bring it in sometime, I'll give it to you. So basically, okay, after that only I'm going to give the goods to him. But he did not give me cash. He told I'll give you, but he did not give entire cash. Second, I sold the goods today. Okay, today is 27th November. And he told that, okay sir, I'll make the payment of 5th December. I told, okay, on 5th December you make the payment. On 6th December, I will give you the goods. 5th December he did not pay. Or third situation. I sold the goods and I told you, okay, you make payment on 5th December, but on 2nd December I'll deliver the goods. On 1st December I understood, boss, he became insolvent. Will I give the goods to him? Obviously not. Why would I give the goods to him? Yes. So see, if goods are, this can be exercised, right of lien can be exercised if goods are not sold on credit, or goods are sold on credit but credit period expired, and buyer becomes insolvent and seller is in possession of goods. And because if I don't have possession, how can I create lien? And it can be exercised only against price of goods. Very important, beta. Example, 100 rupees was the price of goods plus 10 rupees was the go down charges. Buyer paid me 100 rupees. I'm the seller. 10 rupees he did not pay me. Can I exercise lien? Answer is no. It is only for the price of goods, not for any other thing. Am I clear? Sir, are there any situation where this right of lien will not be there with the seller? Yes. In this three situation, right of lien cannot be exercised by seller. First, agreement specifies. If in the agreement only it is written that if the buyer doesn't pay the entire amount, the seller cannot exercise lien, but he can charge interest on the payment. Simple, yes. Second, beta, buyer makes the payment. Obviously, buyer makes the payment. How can I exercise lien? And third, goods are delivered. Like example, if I give the goods to the carrier also, transporter also, now do I have the goods? No, so how can I exercise lien? Am I clear? So these are the situations where lien can be exercised. Okay, I hope you understood. Good. Now, next, right of stoppage in transit. Now when is this right exercised? Example, okay, I initiated delivery. Okay, I told now on 2nd December I was about to give the goods to X in the third case. Okay, I gave the goods, beta. I delivered the goods. Delivered means I initiated the goods. I am in Mumbai, X is in Gujarat. Okay, so from here, beta, I gave the goods to the carrier, transporter. At Maharashtra border, when the goods reached, I understood that, boss, the buyer has become insolvent. He is insolvent. Okay, court has declared him as insolvent. Will I want the goods to reach to the buyer? No. So basically, I can stop the goods during transit. Now there are two methods. I myself, beta, can call, okay, the truck driver, boss, please bring the goods back. Okay. Second, beta, I can myself go like Singham, okay, and stop the goods and take it back and take possession of that. But in case I have given the goods to a transporter who's the agent of whom, beta, who was the agent of buyer, then it is as good as I have delivered the goods. Now, beta, I cannot stop the delivery. Am I clear with this thing? Am I clear? Understood? Okay. Sir, if the goods reached the buyer, okay, but the transporter, okay, asked the buyer, give me some documents, okay, ID cards to so as to hand over the goods. Buyer did not have the ID card. Like, wait, I am bringing the ID card, wait for half an hour. In that half an hour meantime, I understood, better buyer became insolvent. Can I tell the truck driver, carrier to bring back the goods? No. Because the goods have reached the destination. Transit ends. Am I clear? When the goods are in transit, at that time only I can do this thing. So see, right of stoppage in transit means to stop the goods when they are in transit. This can be exercised when goods are not in possession of seller, goods are not in possession of buyer, goods are in transit, and the buyer became insolvent. Am I clear? Understood? Next, right of resale. Now, what is a right of resale? Let's understand. Beta, when I get the goods back in case of stoppage in transit, or I have exercised lien and buyer is not making payment, so what will I do with the goods? Will I pamper the goods? No. What I'll do, beta, I will resell the goods. Am I clear? That right I have. But see here ownership is transferred. So who's the owner, beta? Buyer is the owner. So that's the reason it is very important that first I have to give notice to the buyer that, boss, I am selling the goods. If by this date you make payment, take care, or else forget your goods. Now, beta, take care, that is a genuine thing which we have to do because buyer is the owner. But we are Indians, lawmakers know. we don't follow law as such in true spirit. So lawmaker has made both the provision. Seller resells the goods after giving notice, without giving notice. Okay, so if the seller beta resells the good after giving notice, he has done good, he has followed the law. But there are two situations. Example, our contract price was 100 of the goods, but which buyer did not pay. But after resale beta, okay, resale amount was 120. So that 20 rupees, the 20 rupees extra, 100 तो basically seller will keep, but that 20 rupees extra can the seller keep? Answer is yes. Because beta, he gave notice and buyer did not respond. So indirectly buyer told you do anything what you want to do with the goods. I don't care. Next is resale amount. Contract price was 100, but resale price was we received was only 80. Seller is in loss now. So there is a deficiency of 20 rupees. Can the seller sue the buyer for the deficiency? Answer is yes. Am I clear with this? But if you sell without notice, so you did not follow the law, so law will not help you. The first option, surplus has to be paid back to buyer. What we see here, in case contract price is 100, resale amount 120, 20 rupees profit. Now here can you keep that 20 rupees? No, because you did not give notice. So you have to give it to the buyer because buyer is the owner of the goods. Am I clear with this? Next, opposite. Okay. Contract price 100, resale value 80, 20 deficiency. So can you sue the seller for buyer for the deficiency? No, because seller did not give notice to buyer. Am I clear? Very simple. Very simple. Okay. So these are the rights of seller against the goods if ownership is transferred. But sir, if ownership is not transferred, then first right is right to withhold delivery. That means beta, I will not deliver the goods until you make the payment. Now sir, it is same as a lien. Na? So what is the difference? I'll tell you between lien and withhold delivery. Lien means beta right to retain possession of goods of another. Why? Because their owner is buyer. Here beta owner is seller only. Agreement to sell hua hai. Okay, it's agreement to sell. So basically he will give the goods, but if you are in the place of seller, will you give the goods if you don't get the payment? No, obviously not. Next, other rights of owner. See, goods are with me, ownership is with me, buyer is not paying, so can I resell the goods? Yes. Can I throw the goods? Yes. Can I gift the goods? Yes. Can I myself consume the goods? Yes, I can do everything. Simple. Next, rights of seller against buyer. There are three rights. First is better, see, against goods, so he can do all these things, but against buyer. See, sir, in case seller has transferred ownership also, and plus beta, okay, possession also he has given to buyer. So what he can do? Can he sue for price or not? Yes. Can he get back the goods? No, but he can sue for price. Sue for damage. Okay. Now, obviously, beta, buyer committed a breach of contract. So any damages caused to the seller, can he claim it from the buyer? Yes. Next, suit for interest. Buyer made delayed payment. So can he claim interest seller? Yes. Now, how much interest, beta? If anything agreed in the contract, so basically that interest percentage. But if basically contract is silent, then basically who will decide? Beta, court will decide what interest to be levied from which date. Am I clear? These are the rights of seller against buyer. Okay, everyone understood? If you understood, give me a thumbs up quickly on this. Yes, good, very good. Now one section is there. This section 53, effect of subsale or pledge by buyer. Now what is this case? Na? It's an important provision, market important. I'll write the example here. Mr. Harshmi, okay, I did a sale of goods, sale to Mr. Vishnu. Okay, Vishnu issued me a check. Okay, of next week, post dated check. I told okay, I am transferring ownership to you, no problem. Now Vishnu resold the goods to Nora Fateh. Am I clear? Now she paid him the money. Now tell me, Vishnu is the original buyer and I did sell, so he is a proper owner, and Nora Fateh is the subsequent buyer. Now she will get proper ownership. Yes, ownership she'll get. But beta, what happened in the scenario? I gave ownership, Vishnu. But I told you I will give you possession of the goods only when the check passes. Basically, possession is with Harsh. Possession of. Now Nora Fateh claimed possession from Vishnu. It will be after 1 week you go to Harsh and take the possession from him. Goods are with him. It will okay. But beta, next week what happened? Vishnu's check bounced, dishonored. So basically Harsh is paid or unpaid seller. Now I am unpaid seller. Now I have a right of lien. Now Nora Fateh comes to me and tells, give me the goods. I told, I will not give the goods. I have not received payment. Nora Fateh is telling, I am the owner. I want the goods. So Nora Fateh's ownership versus Harsh's right of lien, which will prevail? That will be the question. Which is same in Mount DF Limited versus J&J provisions. Now what will be the situation? Who will get the right? Okay, answer. What is the provision telling? The right of lien or stoppage in transit is not affected by the buyer selling or pledging the goods unless seller has assented to it. Exception when the seller has assented to the sale, mortgage or other disposition, where a document showing title to goods has been transferred to the buyer and buyer transfers the document to a person who has bought goods in good faith and for value. The answer is beta, Harsh right of lien will prevail except in two situations. First, if Harsh has only allowed Vishnu, like Vishnu told, sir, see, you will get the payment after 1 week, but I have to sell, I'm a trader, I have to sell these goods. Can I sell these goods now only? Harsh told, okay. If Harsh only gave consent for resale, then beta, who will claim possession? Nora. Or second, if Nora had purchased the goods from Vishnu in good faith, she doesn't know whatever happened in the past. Okay, on the basis of document showing title. Document showing title in favor of Vishnu. So if I have transferred ownership to Vishnu and the document showing title is in the name of Vishnu, like example, these are basically these are shares, and basically Vishnu's share name is on the share certificate. Am I clear with this thing? Okay. Or basically it is a vehicle and Vishnu has registered the vehicle in his name. So RC book is in the name of Vishnu, like that. On the basis of that, if okay, she takes Nora Fateh acts in good faith, okay, plus on the basis of document showing title in favor of Vishnu, then beta Nora Fateh will get the right, or else Harsh right of lien will prevail. Am I clear with this? This should. Okay. Now, right of seller against buyer we studied. Right to sue for price, damages, repudiation of contract before due date, that is breach of contract, damages only, and suit for interest. Now, it might be possible, na beta, that buyer is ready to take delivery of goods, but seller is not giving delivery. Nonsense. Yes or no? So basically here, buyer should also get rights against seller. Why should we talk only of sellers from seller's point of view? Did seller give us money? No. The first right, damages for non-delivery, section 57. If seller is not delivering the goods to buyer, buyer is ready to pay. Okay, but so buyer may sue the seller for damages because he did not deliver the goods. Next, suit for specific performance. I told you, no, not I. We did not do this. In Indian Contract Act, for breach of contract, there are remedies. One is specific performance. Now specific performance means what beta? This is for very rare article. Like example, it's a painting of a Mughal period. A agreed to give, sell a painting of Mughal period, which is very rare. Only one painting is there. Okay. Aurangzeb's painting is there. Example. Okay. Or Chhatrapati Shivaji Maharaj, rare painting is there. Now, but it is very rare. Now, B made the payment. A is not giving it, delivering the painting. It's like take damages, I can't deliver. No, you cannot pay damages. You have to specifically give the painting. You have to specifically perform what you promise, because if he pays irrespective of how much damages Mr. A gives to B, can B get another painting anywhere? No. So he can claim specific performance. That is the meaning. Yes or no? Okay. Suit for breach of warranty. Like example, you've studied conditions and warranty with me. If there was a breach of condition and buyer treats it as breach of warranty, or there was breach of warranty, can you sue for damages? Yes, obviously. Next, repudiation of contract before due date. This is anticipatory breach. A told B that boss, I will give the painting to you. Okay, painting or any goods also, normal goods, to B on 5th December. But on 1st December, A is telling B, sorry, I cannot give. So before the due date only is committing breach. That is anticipatory breach. So basically what B can do, B has two options. Wait till 5th and then file a suit, or basically on 1st only he can file a suit for damages. Am I clear with this thing? Okay, these are the two options. Next, suit for interest. Sir, if buyer has made payment but seller did not deliver the goods, the seller has to refund. But if he doesn't refund the money, okay, so buyer will claim interest. He delayed in refunding the money. Okay, so buyer will claim interest. How much interest? Same. Anything mentioned in the contract, then that. Nothing is mentioned, then court may award the interest. Am I clear with this? Understood? Clear? Good. Next in last is auction sales. But nowadays auction sales have been asked in paper many times. So you cannot neglect auction sales and go, okay. Auction sales are very important. Just a second. So what is auction sales? You know, na? People doing auction, IPL auction and all. So there are two examples here. You understand? First example, Harsh, I am selling first my laptop and second my phone through auction. And basically auctioneer here is Mr. X. So now there are many people who came in the bid. These are bidders. They came in the auction. Okay. So basically auctioneer acts as my agent till the article is sold. After it is sold, he is the agent of the buyer, the bidder. Am I clear with this thing? So until article is sold, he is my agent. After it is sold, he is the bidders, that is the buyer's agent. But it is his duty to collect payment and give it to me, like that. Am I clear with this thing? Now, so see, an auction sale is a sale at which auctioneer acts as an agent for the seller, invites person to bid for goods sold. Auctioneer acts in dual capacity. He acts as an agent of the seller till the article is knocked down to bidder. He acts as an agent of the buyer after the article is knocked down to the bidder. Am I clear with this thing? Now, sir, there are section 64 raise some rules for auction, important rules. Sir, when goods are sold in lots, bidder, tell me, I am selling laptop and this is Mr. Z. He gave the highest bid for laptop and we sold it to him. For phone also, he gave a highest bid and took the phone. So now there are two contracts with Z or only one contract? Because same person is the buyer. Answer is two contracts. Every goods, every sale of goods is a subject under auction is a separate contract of sale. Okay, so see, where goods are put up for sale in lots, each lot is prima facie deemed to be subject of a separate contract of sale. That for your information, how it is done, like bidders. Okay, we do auction. Okay, auctioneer we say if there is a this is the particular article, minimum price is 100 rupees. Example, that is invitation to offer. The bidders make the offer. They make the offer. An auctioneer by the fall of hammer, an announcement of sale, that is acceptance. So basically, bidders make the offer, auctioneer gives acceptance. But tell me, beta, what is the second one? Completion of contract of sale. How will the sale be completed, beta? By the fall of hammer. 100 rupees 1, 100 rupees 2, 100 rupees 3. Yes, they can then saying sale. But until this thing happen and announcement of sale, can any bidder who has given the highest bid take back his bid? Answer is yes. The sale is completed when the auctioneer announces its completion by the fall of hammer or in any other customary manner, and until such announcement is made, any bidder may retract from his bid. Okay, so one question was there in CPT. The auctioneer, there was a VAS, VASE, VAS, I called VAS, some people call it as vase. Okay, that was were being sold by auction. One person gave the highest bid, and the auctioneer was like 1, 2, 3, and hammed it, and he was about to announce sale. Okay, like sale, but he hammed it so bad that the vase broke down. Now, who will bear the loss of that, buyer or seller? Answer is seller, because ownership is not transferred to the buyer up till now, because sale is not announced. Understood? Next, right to bid may be reserved. Now, this is the second case. Example, now see, understand this example properly. I took a bank loan from bank, from ICICI Bank, loan of 10 lakh rupees for a car. I was paying EMIs, but suddenly I stopped paying EMIs. So out of 10 lakhs, beta, 2 lakh is paid, 8 lakh is due. So bank, I did not pay payment. The bank collected my, like they took charge on my car. Okay. And they told me, yes, sir, by 5th December you have to make payment. Or else 6th December we'll do auction. At that time, you cannot get the car. If you want, you can also participate in the auction. So here, right to bid may be reserved. So in such cases, I will be the seller. There will be bidders, okay, who are making offer. ICICI Bank will be the agent. Am I clear? That is auctioneer. Clear, everyone? Now, so sir, here, can I bid and get my car back? Yes. So that right to bid is reserved. So basically, seller can bid only if the right to bid, okay, is reserved by the seller, or it is reserved to the seller. Or else, beta, if seller doesn't have the right to bid, can he bid? Answer is no. Am I clear with this thing? Okay. And sellers, that auctioneer can also tell ki we are inviting people to auction. Example, 25 people we invited for auction, and only they can bid. Any other person bids, beta, will that bid be counted? No. Right to bid may be reserved expressly by or on behalf of seller, and for such a right is expressly reserved, but not otherwise. The seller or any one person on his behalf may bid at the auction. Next, where sale is not notified by seller. Sir, in case I am bidding, okay, so I should inform it to the auctioneer, and then auctioneer has to inform it to the bidders. Okay, Mr. Harsh is also bidding to get back his car. If we don't inform it to the bidders, that's a fraud against the bidders. If any person has given the highest bid also, that basically announcement is done, sale, then to beta he can cancel the contract and take his money back. Where sale is not notified to be subject to right to bid on behalf of seller, it shall not be lawful for the seller to bid himself or employ any person to bid at such sale, or for the auctioneer knowingly to take any bid from the seller. Like if I don't have the right to bid, should I bid? No. Okay, and any such person and any sale contravening this rule may be treated as fraudulent by the buyer. So no. Reserve price. We say na, our bidding starts from a base price. Like in IPL also players have a base price. Yes or no? From there only you have to do bidding. Can you bid below that? Like example, I wanted my car back. Nobody came in the auction. 8 lakh rupees is the base price. Can I say 2 lakhs? Okay, and nobody is there and they have to do 2 lakh 1, 2 lakh 3 and sell. No, they can't do it. Okay, the bidding has to be done from the base price only. Okay. Next, pretended bidding. Sir, Example, I did not had any money, but I also participated in the auction. Some people like base price was 8, I told 9. Some people told 10, I told 12. Somebody 15, I told 20. Somebody 25, I told take it, take it, take it. Why I'm doing it now? I don't have any money. I intentionally raised the price because out of 25 lakhs, beta 8 lakh bank will take plus their auction charges. Rest amount I'll get because I am the owner of the car. Yes or no? So intentional breeding. I don't have money. Isn't it a fraud against the buyer? Yes. So then also beta he can cancel the bid. That is not cancel the bid. He can cancel the whole contract only. Even if he has given the highest bid, okay, he understands the fact. He can cancel it, okay, and take his money back. These are rules regarding auction sale. Very important. Understood? So unit 4 is also completed. Everyone understood? If you understood, give me a thumbs up quickly. Yes. Good. So this lesson, Soga, has been completed. Recording stopped. So now we'll do a new lesson. So we have finished Companies Act, Sale of Goods Act. Okay. Now we will be doing Indian Contract Act. Indian Contract Act. We'll be doing that. Okay. So let's start.
Recording in progress.
Okay.
Recording stopped. Recording in progress.
Okay. See, Indian Contract Act 1872. See, Indian Contract Act, the biggest act, the most important act for you people as of foundation is concerned. This is divided into this act is divided into two parts. It has two parts. One is general part, one is special contracts. We'll start with general part today and then we'll go to special contracts later on. Okay. So let's start. See, Indian Contract Act 1872. An act passed in the year 1872 to govern and regulate contracts in India. This act will tell you, it will define you a contract, it will tell you how contracts are formed and how contracts are dissolved. Actually, in the general part there are 6 units. So unit 1 to unit 3 will talk about formation of contract. Unit 4 talks about dissolution, termination of contract. Am I clear? So sir, what is a contract? Okay, you might have studied this thing. Okay, contract section 2 clause H. It is an agreement enforceable by law. Okay, contract is an agreement enforceable by law. Now beta, okay, that is general meaning. But in order to come to that point beta, we need to understand beta what is the recipe of contract, how a contract is formed. Then we will come to that definition. The first thing in contract, there is an offer made by one person. Like example, you're buying a biscuit. You come to me, I'm a shopkeeper, and you said, Bhaiya, do you have a biscuit? Take a dark fantasy biscuit. You're making an offer. I'd say yes, there is dark fantasy biscuit. So I give acceptance to the offer. Yes or no? And this offer and acceptance is in relation to mutual consideration. Consideration means something in return. So what is something in return for me? For my biscuit? Money. What is something in return for you? Biscuit. Yes or no? So offer once accepted and it is in relation to mutual consideration, it becomes an agreement. Agreement plus something will become contract. What is that? Something legal enforceability. Now what is the meaning of legal enforceability? First, if your agreement, general meaning of legal enforceability, if your agreement will be entertained by court, you can take the agreement to the court and the court will entertain that agreement and start the trials. So basically that has legal enforceability. But sir, you don't have to write this thing in, like example beta, if I agree that I'll commit murder for someone and you pay me 1 lakh rupees, offer acceptance is there, mutual consideration is also there, but beta, can we take it in the court of law? But beta, what is the legal meaning of legal enforceability, which you have to write in paper? It means an agreement which has all the essential elements of valid contract. There is a section 10, which is the next section which I'll teach you. In that section 10, there are essential elements of valid contract. If all the essential elements of valid contract are present, okay, in your agreement, then that agreement has legal enforceability and it is a contract. Okay. Now see. That's the reason there is a question. All contracts are agreements, but all agreements are not contracts. True. Because only those agreements which have legal enforceability will become contract. Yes. Now essential elements of valid contract. Just now I told. All these points should be present in your agreement, then only your agreement has legal enforceability. First, two parties. There should be minimum two parties to form a contract. One making offer, another giving acceptance. Obviously, na, okay. Without that beta, can there be a contract? No. Can I make offer to myself? Can one person enter into contract with himself? No. Obviously not. Harsh one give me biscuit, Harsh to take biscuit. Will it be there? No. Next, legal obligation. Now whenever you make an offer and the other person gives acceptance, offer means I will do something for you. Acceptance means yes, against that something I will also do something for you. Like you made an offer, give me the biscuit, I promise I'll make payment. And I gave biscuit, I took money, I'm like, okay, I'll give biscuit. So here beta, your offer and acceptance is in relation to some promises. Your promises should be your legal duty to perform, not a social duty. If you create social duty by offer and acceptance, it is not a contract. Like example, I made an offer that I will pay you 1 lakh rupees. You manufacture 10,000 shares for me. You manufacture 10,000 shares. Is it my legal duty to pay 1 lakh? Yes. But if I invited you to dinner at my home, come at my home, I'll feed you good food. Today is my birthday. You came to my home, expended money on your petrol and came to my home. I told sorry, party cancel. So basically, can you sue me for that? No. That is just a social duty, not a legal. It was not my legal duty to feed you or give you party. Simple as that. Next is consensus ad item. Now what is consensus ad item? Consensus at item means meeting of the minds in the same sense. Okay, meeting of the minds in the same sense. Like example, if you are thinking something on the subject matter, I am thinking something else, then it is not a contract. Like example, I made an offer. I was into the business of selling horses. I sell lot of horses. I made an offer that I am selling my horse named Chetak, but I told I made an offer I am selling my Chetak. Actually, I also had a scooter Chetak, a Bajaj Chetak. So Mr. X read the offer and he told, okay, I offer to buy your Chetak at this price. I told, okay. Now he is thinking beta Bajaj Chetak, scooter Chetak. I am talking about horse Chetak. So did our mind think on the subject matter in the same sense? Answer is no. Understood properly? Here, it's not a contract. Next is free consent. Now what is free consent beta? Well, law tells that so in order to form a contract beta you should give consent. Now or free consent. Answer is beta free consent, not just consent. Sir, what do you mean by free consent? Free consent means consent without flaws. So if you say yes to the offer because of any of these 5 flaws, it will not be a contract. Okay? What is the 5 flaws? Coercion, undue influence, fraud, misrepresentation, mistake. Sir, we don't know what is this. Don't worry beta. In today's lecture only I'll explain every point properly. Am I clear? Next. Parties must be competent to contract. Yes, that means parties must be eligible to contract. So, sir, what do you mean by eligibility? Law tells beta if you that you should not fall under these 3 points. If you fall under these 3 points beta, then you cannot enter into contract. You are not eligible. First, if you are a minor, not allowed. If you are of unsound mind means a person who cannot understand the terms of agreement. Okay, then not allowed. If you are disqualified, like example, you are insolvent or an alien enemy. Alien enemy means a person who is a citizen of a country with which India is in terms of war. So basically, can you enter into contract in India? No. Or can you Indians enter into contract with them? No. So basically, party should not be any of this. Then only better they can enter into contract. Next, lawful object and consideration. Tell me the purpose of the contract should be lawful or unlawful? Lawful. Yes or no? Okay, it should be lawful. Like committing murder of someone, is it lawful? No. Again, consideration should also be lawful. Like example, I tell you that I'll supply you with a goods, furniture. You don't pay me, you supply me drugs. Is the consideration lawful? No, obviously not. It's not a contract. Next, possibility of performance. Sir, possibility of performance tells that whenever you make an offer and acceptance, so whatever we promise that I'll do this thing for you should be possible to perform. If it is impossible, beta, we can't enter into contract. Like, can I, like this one minister had told, I'll make a machine for you. From here I'll put potato, from that side gold will come out. Tell me, if I tell this thing, okay, give me 1 crore rupees, I'll make a machine. From here you put vegetables, from that vegetables will turn to gold. Is it possible? No, it is impossible. So it's not a contract. Next, if you take this kind of contract with the judge will throw you and the contract both outside the court. Agreement should not be declared void by the law. Yes, you cannot enter into agreement. It is declared void by the law. Law of the lanterns, you cannot enter into this contract. Say, example, agreement to sell Taj Mahal. Can you sell Taj Mahal? No. So that is declared void only. You can't enter into such contracts. Next, terms of agreement must be certain. Yes. Certain means clear. There should not be any uncertainty in the terms of agreement. Like example, if I tell you, I offer to give you job and you say yes, but I say salary will be as per my mood. Are the terms clear or unclear? Unclear. What is mood? It is not clear. Yes or no? One more example I have written. Mr. A contracted to purchase a radio from Mr. B for 2000 rupees. If his favorite songs are played, or else 500. Arey, what nonsense. What is if say his favorite songs are played? Is it certain or uncertain? Uncertain. His favorite song may change every day. You will never get 2000 rupees. Simple. Yes or no? Next. Other formalities. Now what is other formalities? Like, these are only in certain case contracts, not in all contracts. Only in specific cases to be complied. Like if you buy a biscuit, your contract can be oral also. Yes, buying biscuit. But there are certain contracts which should be in written format only. You have to pay stamp duty and registration fees. Then only better it will be a valid contract. Example, a contract to buy immovable property. It should be in written only, and stamp duty and registration is to be paid. If it is pending, but will it be a complete contract? No, agreement. It is just an agreement. It is not a contract. We call it as unenforceable contracts. Did you understand? So basically, if all these essential elements of valid contract are present in a contract, then only beta take it is a contract, or else. Am I clear with this thing? Understood? Good. Next, okay. We understood what is contract, what are the essential elements of a valid contract. Now the next one. Now this is important. We have to understand classification of contract. It's very important for you to understand unit 3 specifically. Sir, classification of contracts, we are not studying types of contract. We are studying classification of contract. What do you mean by classification? It means, okay, classification is always done under certain basis. Okay, like example, can you classify me on the basis of gender? Yes. Can you classify me on the basis of marital status, married, unmarried? Yes. Can you classify me on the basis of nationality, Indian, non-Indian? Yes. Can you classify me on the basis of religion, Hindu, Muslim, Catholic, Sikh, Jain, others? Yes. So one person can be classified under different heads. He can be put under different brackets on the basis of something. Similarly, a contract can also be classified under 3 bases, and it will be put, one contract will come under 3 brackets. So what are the bases? See, on the basis of validity. First, valid contract. Valid contract, basically on the basis of validity is whether the contract is valid or not. On that basis we are classifying the contract. So basically first is valid contract. Valid contract means what beta? An agreement enforceable by law. Section 2 clause H. All the essential elements of valid contract are present. Very simple. Okay, the thing which we thrive for. Yeah. Next we will do here. Then we'll go to void contract. Now understand beta, there is one word void contract and one is void agreement. Now what is void contract? See, void contracts, okay. Void contract's definition is like a contract is void when it ceases to be valid. Okay. What does that mean? I understand. Sir, void contract means a contract in simple term which was valid at the time of formation, but subsequently it became void. Okay. So let's take an example. Mr. X, this is just for understanding. Okay. Mr. X decided to appoint Mr. Y as his driver. Okay. Now, and told you come from next month for driving. It's a valid contract, yes. But before the next month came, like this month, end of the month, that person, the driver died. Mr. Y died. Now can that be a contract? No. It was valid at the time of formation because why the driver was there, but now he's dead. How can you make a dead man drive for you? Basically it is void contract. Am I clear with this? Now, but what is void agreement? Void agreement means an agreement which was never enforceable by law. Means it never had all the essential elements of valid contract. So it never turned into contract. Okay. So the example, agreement with minor. Did it had all the essential? Agreement with minor cannot be done. It is void from the beginning itself. So that is void agreement. I hope you understood the difference between void contract and void agreement. Void contract was valid first, then became void. Void agreement is void from the beginning itself. Next is illegal agreement. Now what is illegal agreement? Any agreement which law forbids. Forbids means punishable by law. Example, to murder someone. A and B, beta, A gives money to B and tells B, go and murder someone. If police understand that, they will catch both of them. So that is punishable by law. That is illegal agreement. Am I clear with this thing? Next, voidable contract. Now what is voidable contract? Let's understand. Voidable contract means a contract where one party, that is aggrieved party, has a right to treat the contract valid or void. Okay, what is aggrieved party? Party suffered losses. That party will have the right to treat the contract valid, keep the contract valid, or turn the contract void. He or she is able to treat the contract valid. He or she is able to treat the contract void. So voidable contract. I'll give example. Like I sold you some goods on account of fraud. I did fraud with you and sold you some goods. Basically, if I did fraud with you, you are the aggrieved party. So now you get a right to treat the contract valid or treat the contract void. That is voidable contract. I sold you a repainted car. Pre-owned car you are buying, I sold you a repainted car. You told me that, sir, if I don't want a repainted car, I don't want an accidental car, but basically I painted in such a way you didn't understand. So it's a fraud. Later on you understood. Can you cancel the contract? Yes, that is voidable contract. Now what is the major difference between void contract and voidable contract? Understand. Void contract, nobody can make it valid. It can never be turned out to be valid now. And a person died, how can you make it valid? But voidable contract, one party can make it valid. Am I clear? That is a major difference. Next is unenforceable contract. Just now I told there are certain contracts which require special formalities to be complied. Okay, like stamp duty, registration, fees is to be paid. But unless and until you do that thing, okay, basically can you enforce the contract in the court of law? No. The moment you pay stamp duty and basically registration fees, then it is a proper valid contract, can be enforced. For the time being, it is unenforceable. Am I clear with this? So basically these are the 5 contracts which can be classified on the basis of validity, or a contract can be classified into any of this point on the basis of validity. Valid, void contract, void agreement, voidable contract, illegal agreement, and unenforceable contract. Now there is a question. All illegal agreements are void, but all void agreements are not illegal. Answer is true. Like committing a murder is illegal agreement and void, but agreement with a minor, is it illegal? I sell chocolate to a minor, will police catch me? I'm minor, you sell chocolate to minor? No. So it is not illegal, it is void, but it is not illegal. Am I clear? Okay. Next, classification of contract on the basis of performance. 3 bases are there: validity, performance, formation. On the basis of performance means what? Whether the contract is performed or yet to be performed, on that basis we classify contract. So here first is executed contract, second is executory contract. Executory contract means what beta? Executed is past tense. So basically contract is already performed. That means both the parties have fulfilled their promises. You gave me money, I gave you biscuit. That's it. Contract is performed. That is executed contract. Contracts where both parties have fulfilled their promise. Executory contract. Now what is this? Executory means incomplete. The contract is still going. Now executory contract will be divided in 2 parts. Either it will be unilateral executory contract or it can be bilateral executory contract. What do you mean by unilateral executory contract? Unilateral executory contract means, uni means single, means one party has performed this part of promise, other party is yet to perform. Bilateral means both are yet to perform their promise. Like example, you told you will pay fees to me for teaching law. I told okay, I will take the law lecture. Now beta, I have not finished the syllabus, you have also not made the payment. So that is bilateral. But I have finished the syllabus, you are still to make the payment. So that is unilateral. Am I clear with this? Understood? Okay. Next, classification of contract on the basis of formation. How was the contract formed? On that basis we are classifying contract. In that first comes beta express contract. Express means beta you express the contract by words, either oral or written. The contract formed by using word, that is called as beta express contract. Second is implied contract. Now implied contract means beta it is understood by implication of law. So contract which is understood by implication of law. Okay. Law tells that you have entered into contract. Okay, even if you are arguing that I have not entered. Like example, I went to a railway station. One person, a coolie came dressed as a coolie. He gave me a smile. I also gave him a smile. He picked up my bag. I allowed him to pick up the bag. And he's telling me, sir, which coach number, which platform? I told platform number 1. He went to platform number 1. Now he's asking, sir, which coach? I told this coach, this seat. He kept the goods there. I'm like, thank you. Well, thank you, paisa nikalo. Give me money. I told, Arey, what money? You never told I have to pay money. You smiled, I smiled. So basically, am I bound to make payment to him? Yes, because it is understood by implication of law that a person who has given service to me, I have to pay him. Yes or no? Next is tacit contract. Now, tacit contract beta is actually a part of implied contract only, but it means beta a contract which is done silently. Tacit means silently. Both the parties know they are doing contract, but nobody talks to each other. Silently it is done. Like example, if you go to DMart, if you go to IKEA, okay, and basically you pick up the goods, go to, and there now in IKEA channel there are automated, okay, you can say machines. Okay, you just have to scan it, take scan. Okay, it will prepare the bill. You make payment, scan it again, basically go away. Do you even speak? Do the IKEA people speak to you? No. So that is what a tacit contract. Am I clear with this thing? Like withdrawing money from ATM, in auction beta, raising the flap for increasing the bid. What is that beta? You don't even talk. That is tacit contract. Am I clear with this thing? Next is e-contract. Now what is e-contract? E-contract means a contract which is formed using electronic means. Another name for that is EDI, electronic data interchange contract, mouse click contract, okay, cyber contracts. ये सब नाम है. Like online shopping, you do it through mobile, you use electronic means. Yes or no? Online shopping, Zomato purchase. Yes or no? Okay, all this Swiggy orders, all these are what beta e-contracts. Okay, understood properly? Okay. One more is there, quasi contract, but that we'll do in unit 6, not now. So there are 3 contracts. Okay, you can classify contracts on the basis of validity, formation, and performance. Now, like example, beta example. You have paid fees. Example, you paid fees. Okay, for lecture. So on the basis of validity, where it will come, beta, valid contract. On the basis of performance, where will it come? If syllabus are finished and basically you also paid fees, then executed, or else it will come in executory. And on the basis of formation, okay, it will be express contract. Simple. Okay, because obviously, okay, you came, you filled the form. Yes or no? Basically, it is express contract. You ask here, sir, when will the syllabus be finished? Everything, and we told this much fees is there. That is express contract. Am I clear with this thing? Understood? But YouTube people, better. Okay, is it a contract between us? No. Okay, in fact, I think it is free for you people also. Actually, it is not a contract. The reason is that it is free. We have offered you, we will not do it, but if you told, okay, I will take lecture on this date, and if you did not take lecture, can you sue us? Answer is no. Well, there was only one side consideration. Clear, everyone? Yes. Okay. Now actually the law starts. Now we have to study the ingredients of contract: offer, acceptance, consideration, I mean all these things. Let us start with offer. Now the contract starts. Sir, what is offer? Section 2 clause A. When one person shows his willingness, signifies his willingness to another to do or abstain from doing something with a view to obtain the assent of such another to such act or abstain, he is said to make an offer. So what is this? I'll explain. Very simple. X and Y is there. X is me, Harsh. When can I say that I am making an offer to Y? When one person signifies his willingness to another, tells to another to do that I'll be doing something for you, or abstain from doing. Abstain from doing means not to do. Not to do. That I will not be doing something for you. Whether we to obtain the assent of son another, so that this person should say yes, he should agree. Okay, and he should also do something for me. Then beta, okay, then I have made an offer. When one person tells another that I'll be doing something for you, or I'll not be doing something for you, so that you should say yes, and you should also do something for me. Okay, so that is what beta I have do, and you should say yes to that doing or not doing. That is what is nothing but offer. Okay, so again, when one person tells another that I'll be doing, first I'll take doing one example. When one person tells another that I'll be doing something for you, you also do something for me. The other person says yes, that is the purpose. So I have made an offer. Example, I'll manufacture chairs for you, you pay 10,000 rupees. An offer. But sir, doing something understood, not doing something is also a consideration. Doing something is a consideration, so you will say yes for that. Not doing something will also be a consideration. Yes, see, I say I will not be doing something for you. Say yes to that and you do something for me. Okay, so I have made an offer. Example, this is my land. I gave the land to Mr. Y on 10 years lease. In 10 years he made a factory here. After 10 years land comes back to me. I am about to demolish this factory. But Y is like, Arey sir, don't demolish sir, it is my factory, I am earning good money. I told, okay, I shall not demolish your factory, provided you pay me 5 lakh rupees rent every month. I shall not do this thing. I'm not doing a thing for him. Is it a consideration for him? Am I clear? So am I making offer or not? Understood properly? That is section 2, subsection A. Okay? Up till now everything clear? I hope yes. If you understood, just give me a thumbs up quickly. If you understood, give me a thumbs up quickly. Very good. Good. See, now rules of offer. There are certain rules of offer. See, what is offer we understood, but in order to constitute a offer as a valid offer, okay, there are certain rules. Okay, offer should follow these rules, then only better it will be a valid offer. You know what are those rules? First, offer must be capable of creating legal relationship. We have done this thing. In that case law is Balfour versus Balfour. What happened in this case? A husband promised to pay monthly allowance to his wife. Okay, he just told me, okay, I'll pay you monthly this much amount, okay? Because you take care of the house and all. Now, first month he paid, second month he paid, third month he did not pay. Now that wife filed a suit against him in the court that you made an offer that you will pay me 10,000 rupees. I told, okay, take it. I accepted the offer. We had a contract. Now you are not paying me, Dumbo. Can she file a suit? Answer is no. Because paying that monthly allowance, was it the legal duty of the husband? Am I clear? There was no contract. Next, terms of offer should be certain. Very important. Terms of offer should be certain. We studied na. It should not be vague. Acha, tell me, will it be offer, valid offer? I am Mr. Harsh. I sell different types of oil. One day Mr. X offered to buy 2 liters of oil from me. And I told, okay, at this price. Is it a valid offer? Answer is no. Because which type of oil beta did Mr. X tell me? No. The terms of agreement are not certain. Okay. Next, offer should be communicated. In the ingredients offer, then acceptance comes. So if I don't communicate my offer to you, can you give acceptance? No. So if you give acceptance without knowing about the offer, if I don't communicate the offer to you, will it be a valid acceptance? Like example, for case law is that Lalman Shukla versus Gauri Dutt. So in this what happened? One guy was there, his nephew ran missing, went missing. So this guy and his servant both started finding the nephew. The owner he came back and the servant continued searching. Now owner was like, yaar, his boss was like, how will he find my nephew? I'll give a newspaper advertisement. So he gave a newspaper advertisement. Whoever finds my nephew or tells about him, I'll pay this person this much reward. Now the servant, okay, he found the boy without reading, okay, that offer which was given in the newspaper. Now beta, tell me, was the offer communicated to him? No. So can he give acceptance? No. So can he claim that reward? Answer is no. But if he had read that and then beta ticket, he found the boy, then beta, yes, then it is a contract because the offer was communicated to him. Am I clear? Next, offer can be expressed or implied. Obviously, expressed offer means by using words. Implied offers basically be without using words. Am I clear with this thing? Okay, so offer can be expressed as well as implied. Like you said, some people propose, I love you, like that. Some people take they go on the knees and show the ring. That is implied offer. Simple. Yes or no? So offer can be conditional. Now very important. Offer can be conditional. Like if I give a offer subject to a condition, that means better before if you want to accept the offer better, you have to fulfill the condition. Like example here, JK sir offered to Mr. Harsh to teach in the institute. He offered me that you teach me in the institute for this much money. But provided Harsh sir gives a demo lecture with positive feedback of students. Is it a conditional offer or not? Offer can be conditional. If I don't give demo lecture or I feel I give a demo lecture but with negative feedback, can I accept the offer? Answer is no. Understood properly. Next, offer should not contain a term non-compliance of which would directly lead to accept. This is my favorite point. What is this? Tell me, can you write, see if I write like this, I'm making an offer to you. If you do not listen to me, if you do not reply to my letter, if you do not do what I say, it will be deemed that you are rejecting my offer. Is it okay? Yes. But if I say if you do not do what I am saying, you do not reply to me, okay, it will be deemed that this offer is accepted. No, obviously, yeah. If you are not interested, you will not even reply to me. Can I take it as acceptance? No. Understood? So in offer, you cannot put a term that if you do not do this thing, it will lead to acceptance. Okay. Like Mr. Harsh writes a letter to Mukesh Ambani to purchase Antila, 15,000 crores valuation for rupees 1 lakh and mentions if Mukesh Ambani doesn't revert in 2 days, it shall be presumed to be accepted. Will it be offer? Obviously not. Am I clear with this? Not a valid offer. If there is no valid offer, can there be a valid contract? Answer is clear, everyone. Yes. So I'll give you 5 minutes break now. Okay? And then we will continue. So after 1 hour 15 minutes order, okay, I'll give you 5 minutes break. Okay, 2 to 5 minutes breaks. Okay, then we will continue. let's continue guys, let's continue. Now we have to do types of offer. We understood rules of offer, we understood what is offer. Now we have to do types of offer. First is general offer. What is general offer, beta? General offer means an offer made to public at large. Now who can accept the offer, beta? Very important, a person who knows about the offer. A person who doesn't know about the offer cannot accept it, like Lalman Shukla versus Gauridal. For this there is a case, Carbolic Smoke Ball, Carlyle versus Carbolic Smoke Ball and Company. Now what happened? See, in this case what happened, one lady was there, Carlyle, okay, and there is one company, Carbolic Smoke Ball Company. Carbolic Smoke Ball is the medicine which this company makes. Now it was a rumor or a fact also, or a myth also, whatever it be, that if you consume this medicine, the side effect of that is influenza, you will get influenza. So nobody purchased it. Okay, sales started going down. So Carbolic Smoke Ball Company gave a advertisement in newspaper, all these are rumors, taken nothing like that, we have tested everything. If any person consumes our medicine and gets influenza, we will pay 100 euros to that person as compensation. It was an offer made. Now Carlyle read about that in the newspaper and she's like, okay, then it might be a rumor. So she took that medicine. Okay, she got influenza side effect. Now tell me, beta, she went to the Carbolic Smoke Ball Company for that 100 euros compensation. Carbolic Smoke Ball Company, she told, why should we pay you? She told, you made an offer, I accepted the offer by consuming it. I got influenza, you have to pay compensation. They told, Arey, we don't even know you. This is the first time we are seeing you. How can we make an offer to you? There is no contract. Was there a contract? Yes. Because they made a general offer. Am I clear with this thing? And any person who knows about the offer can accept it. Next is specific offer. Now what is specific offer? Specific offer means an offer made to a specific person only. So who can accept that offer? Only that specific person. Offer made to particular person, the person to whom offer was made can accept the offer. Now what is cross offer? Now cross offer means both parties are making identical offers to each other without knowing that the other person has made identical offer. So basically this is just an offer. Is there any acceptance? No. Just because you gave me an identical offer which I gave you doesn't mean that that is an acceptance. So it is just an offer, it is not a contract. Okay. Parties making identical offers to each other in ignorance of others' offer. These are just offers and not contracts. See the example. Mr. A sent a letter of offer to sell his car to B for rupees 50 lakh. B, without knowing the same, that A has sent the offer, he also sent a letter of offer to purchase his cars for 50 lakhs. And A wrote, if you are accepting the offer, your acceptance should come through letter only. Am I clear with this thing? What B did, B is like, Arey, I made an offer to buy it for 50 lakhs. A also made the offer to sell it for 50 lakhs. Obviously, there is a contract. He went with this 50 lakhs. He told me, give me the car. Can A refuse to do it? Answer is yes. He's like, Arey, we had a contract. Okay, you made an offer 50 lakh, I also made an offer for 50 lakh here. It is acceptance. Basically, there is a contract. Okay, you cannot now turn around. Answer is no, there is no contract. It is just a cross offer. There was never an acceptance. Acceptance had to be given by post, which would never happen. Am I clear with this thing? So there is no contract. Now the next is counter offer. Now what is counter offer? Counter offer means, beta, offeree, like I make an offer to you, you cancel my offer and you make a new offer, like you buy vegetables, no? So I told I am the person who is selling vegetables. I told I offer to sell you vegetables for 100 rupees kg. You told forget 100. Okay, I am buying but at 80 rupees kg. You cancelled an offer, my offer, and you made a new offer. So you are the offerer or I am the offeree now. Am I clear? That is counter offer. Am I clear? So counter offer is nothing but conditional acceptance. See, I told I made an offer, you are telling okay, I accept, I will buy vegetable from you, but not at 100 but at 80. So did you give conditional acceptance or not? Acceptance subject to condition. So basically that is counter offer. That is the reason we tell that offer can be conditional but acceptance can never be conditional. Okay, this conditional acceptance is counter offer. Okay, next, standing offer, continuing offer. Now what is this? Many people would say you, sir, an offer open for a big period of time, like pantaloon sales, okay, or basically Flipkart big billion sale open for 10 days is a standing offer. No, it is not an offer. In fact, it is not even an offer. It is an invitation to offer. And what is standing offer? I'll tell you with an example. See, this is an offer made for a continuous period of time. This is an offer for open for a big period of time. But how questions will be asked on it? Understand. See, example, on 1st January 2021, I offered to, I'm a person who supplies milk. I offered to provide milk for a year to Miss Pooja at the rate of 50 rupees per liter. I told okay, that is my rate, which is for year to year, 50 rupees per liter. So did I make an offer that I'll supply milk for 1 year at 50 rupees? Okay, charges open, that is basically okay, continuing offer or standing offer. Am I clear with this thing? So the rate 50 rupees will be fixed for a year. Pooja told okay, every day you come to my home, okay, morning if I want milk I'll let you know. So 2nd January I went to her home and she purchased milk. She brought the utensil. I gave the milk. So when she brings the utensil for that milk, that is acceptance. So offer, acceptance. Every day better individual acceptance is given. And every day there is a separate contract and she is bound to pay. So she is bound to pay for this. 3rd January same thing happened. I went to her home. She gave the utensil. I gave the milk. Okay. And basically it's a contract. This is contract number 2. Now 4th January, I went to her place. She told today I don't want milk. So there was no offer, no purchase. So offer was there, but was there any acceptance given? No. So there is no contract. So is she bound to pay? There is no. The same example can come to you in the form of wheat, rice and all. Okay. Mr. A offered to sell wheat at the price of 100 rupees kg for a year. Okay. Basically the other person told okay, whenever I need, I will ask it from you. I'll tell you, you supply it to me. Am I clear? And then better case law will come. Acha, tell me, can Harsh change the price in between? Answer is no. If I change the price better, then it's a breach of contract. Am I clear with this thing? Understood properly? Can Harsh tell, or madam, 4th you did not take the milk, you are committing a breach? No. Because offer was there. Acceptance is basically taking the milk. Understood? So Harsh can't change the price, but can Pooja stop taking the milk? Yes. Am I clear? This is how the questions will come to you. Understood properly? If you understood, give me a thumbs up quickly. If you understood, give me a thumbs up quickly. Yes. Good. Now this is important. Okay. Offer and invitation to offer. But offer and invitation to offer are two different things. What is the difference, beta? Invitation to offer comes before offer. Okay. Offer comes before acceptance. So if my purpose is to make offer, what I expect from you, acceptance. If my purpose is to make invitation to offer, I expect offer. Invitation to offer means I invite you to make an offer to me if you are interested. If I make offer and you say yes, it's acceptance, it's a contract. It concludes to contract. I make invitation to offer, you say offer, you make offer. Does it conclude to a contract? No. The invitation to offer and offer are two different things. I'll give you an example. Like when you fill application forms for college, yes or no? You go for admission. So first college issues you prospectus. Okay, application form. So what is that prospectus? Invitation to offer. This is the fee structure. If you are in fee structure, this is all these things. Like a garden is there, a cafeteria is there. If you are interested, you fill the application form and make us an offer. Then we'll decide whether to give admission or not. So prospectus issued by colleges, invitation to offer. You filling the application forms and giving to colleges offer. Am I clear? Then basically price tags, menu cards, all these are what beta? Prices on menu. Okay, all these are invitation to offer, not offer. If you tell minimum price of this is this much, minimum price 100 rupees, you put a price tag there. Okay, so basically what is that? Is it offer? No, it is invitation to offer. This is the minimum price. You make an offer, I will decide whether to give it to you. Am I clear with this? Yeah. Offer precedes acceptance. Invitation to offer precedes offer. Offer concludes to contract. Invitation to offer does not conclude to contract. Person making offer expects acceptance. Person making invitation to offer expects offer. The prospectus issued by college is invitation to offer. Students filling the admission form and submitting it to college is offer. Like example, you are walking around and you see basically for rent, to let, rupees 5,000. So it is offer or invitation to offer? Invitation to offer. Am I clear? The Harvey versus Facey. In this case also same thing happened. Okay, there was one person who told Mr. X sent a letter to Y. Hey boss, I offer to buy your goods. Okay, first was offer. Second, telegraph me the minimum price. Y just told the minimum price. He did not reply to this. Then he told X again sent a letter. Okay, I agree to buy your goods at this price. Y did not reply to that. So that price told by Y, okay, price mentioning the price, is it an offer? There was no accept. There is no contract. Am I clear? See, you will have case laws every time. 70 to 80% of the questions will be case laws only. Okay, straightforward questions will be hardly 20%. Understood? 20 to 30%, not more than that. And it is good. Case laws coming is good, beta. Okay, you just have to write the provisions, text of the provision, facts of the case, and basically opinion. If it's straightforward question, you have to write a lot. Kind of by heart and all stuffs will be there. It is better. Okay. Now, so basically, offer part is completed. Okay. Am I clear with this thing? Sir, when you have to accept the offer, beta, before the offer lapses for you. Now, okay, offer part is done. Now we will be studying beta acceptance part. Now, what is acceptance? Offer, acceptance, second ingredient. What is written? Sir, when the person to whom offer is made signifies his assent, the offer is said to be accepted. When the person to whom offer is made, if he says yes, then beta, it is deemed that he has accepted the offer. And then there will be a contract, yes or no. But beta, as offer has some rules, acceptance also has some rules. Now, what are the rules of acceptance? Let's understand. Acceptance must be communicated. Do you remember? Offer must be communicated. Lalman Shukla versus Gauridas. Similarly, acceptance should also be communicated. Now, there is a case law for that. Brogdon versus Metropolitan Railway Company. Now, what happened in this case? Understand. See, there was a person, Brogdon. He was a coal supplier. He made an offer that I'll supply coal, okay, to you. To who you means Metropolitan Railway Company at this price. But there was a manager of this company who had to accept or reject the offer. What he told, he wrote accepted and basically kept it in his drawer. Kept in his drawer. So did he communicate acceptance? No. The B sold the coal to someone else, to Mr. C. Now the manager is telling you are committing a breach of contract. You made an offer, we accepted the offer. Take it now. How can you sell that coal to someone else? Did they give acceptance? No, acceptance was never communicated to Brogdon. How will he know? Come to know better. Okay, boss, you have given acceptance. You kept it in the drawer. Should I go in the drawer now? So there was no contract. He can sell it to C. Am I clear with this thing? Next, mere silence is not acceptance. There's a case law for that. Feldhaus versus Bindley. Okay. Here what happened? Mr. X was the uncle of Mr. Y. Mr. Y had many horses. He appointed an agent Z to sell all horses. Now Mr. X, okay, he wrote a letter. Why? I offer to buy one horse from you, one particular horse, okay? He named that horse for 30 euros. If you don't reply within 3 weeks, it will be deemed to be accepted. Can this be acceptance? Why did not? And Z sold all the horses. Now uncle comes to know. Now uncle is filing a suit on the agent. How dare you sell all my, how dare you sell my horse? There was a contract between me and Y. Was there a contract? No, because silence, can it be termed as acceptance? No. Am I clear with this? Am I clear? Next, acceptance must be communicated by a person who has the authority to accept. If it is a specific offer, it should be accepted by the person who has authority to accept. Now, see, what is this? Bolton versus Jones. Okay. Now, here, understand. Mr. A was debtor of B. B was the creditor. He had supplied, he had given some loan, something like that, and Mr. A had to pay. But Mr. A now was not paying. So what B decided, na, A was a manufacturer. Okay. So B gave a order, made an offer to him that you supply me these goods of yours. I'll make payment. Okay, you supply the goods, I'll make payment after some time. So what was B's idea? That he'll take the goods, sell the goods, okay, to some X person and recover his loan because A is not paying it. So he sent a letter of offer at A's address, A's office. But by that time, beta, A had sold his business to C. But offer was made in whose name, beta? A's name. Now what C thought, ki, I have purchased the business, na, so it is my offer. So he gave acceptance. He sent the goods and claimed payment. B is like, no, I am not going to pay. We don't have a contract. He is like, you have a contract, you made offer. I accepted the offer by selling the goods. Question is, was there a contract? Answer is no, because offer was made to whom, beta? A. So can C accept that offer? No. Offer has to be accepted by the person to whom offer is made, who has the authority to accept. So basically acceptance by C is invalid. Am I clear with this thing? Understood? Okay, so there is no contract. Next, acceptance must be absolute and unqualified. For these also there is a case law, Neil versus Merritt. We studied now, offer can be conditional. Can acceptance be conditional? No. If you want to give acceptance, you have to give acceptance without any conditions. Just say yes or no, that's it. Conditional acceptance is counter offer. It is not a acceptance. Okay. Next, acceptance must be given within specific time told, or within a reasonable time. Now what is reasonable time? Courts will decide reasonable time as it varies from case to case. If within specific time or reasonable time, if you don't give the offer, okay, the offer lapses. Am I clear with this thing? And once the offer lapses, after that can you again revive the offer? No. Next, acceptance can be expressed or implied. Okay. Now understand, this is important. Sir, acceptance can be expressed, like offer can be expressed, acceptance can also be expressed. Okay, by words you can say accepted, or by implied, by the conduct, okay, you can give acceptance. And like here, okay. That Carlyle versus Carbolic Smoke Ball Company. She consumed the medicine. That is implied acceptance. She did not write a letter, I am accepting, okay, and I am consuming medicine. No, It can be implied. On the same parallel, there was a case Lily White versus Manu Swami. Now what happened in this case? Understand. See, that decision what is given in the ICI book, actually it is not correct. The decision was something else. I'll tell the actual case also, take a actual decision also, and basically what you have to write in paper. There was one Mr. X. He was a dry cleaner. He used to clean clothes for others. Okay. What he used to do now, when he used to take the clothes, he used to give a receipt. Okay. Bill. Okay, this is the bill. No, dates of case law is not required to be remembered. Okay. So he used to issue receipt, and in receipt what he used to write now, in case there is a loss of the goods, I lost your clothes and all. So basically X will pay 15% of value of goods, value of the clothes. Now one day what happened, okay, Miss Y, she was Lily White, she gave some clothes of her for dry cleaning, and Mr. X beta misplaced it. Now he is giving beta 15% of the value. She's like, no, I have want full value. What 15%? It is lost to me. But in your ICA book, it is told that once you accept that receipt, it is written beta 15%. It is deemed that you have accepted it because you did not protest it at the time when you took the receipt. Okay, so this is implied acceptance. But what is the actual case? Decision. The actual decision was like what court told was, this is nonsense. The terms of agreement are not certain. Okay, if you take it as a contract, this is valid, then beta X will do all this thing only. He will intentionally misplace, tell that he misplaced, and 15% of the value of the clothes he'll give. It is a different, it's a clear case of fraud. So basically there is this terms of agreement are not certain. There is no valid contract. X has to pay the full value, okay, of clothes to buy. This was the actual decision. But in ICI, it is taken in implied acceptance. Am I clear with this thing? Okay. Next beta, acceptance should be in prescribed mode. What is this? But at this point tells that if I have given a letter of offer to you and I tell that boss, I need acceptance only through letter, so you have to send the acceptance through letter. If you don't send the acceptance through letter, what is the consequence? See, A made an offer letter to B, sent an offer letter, and he told acceptance must be through letter only. Now there are two options, two scenarios. B sent letter of acceptance, yes, so it's valid acceptance. But example, he message, I accept your offer. So basically first option is A may not object and is like, okay, I'll treat it as valid acceptance. But if B objects, like our auditor is not allowing, so basically he objects and he has to inform, ki boss, you give me letter of acceptance. So two options here also. B sends letter of acceptance like a good boy, so it is valid acceptance. But if B did not reply only, so basically it is not valid acceptance, so void, it is void, so there is no contract one. Okay, these are the rules of acceptance. Understood properly? Okay. Clear? Next is contract through post. This is important. It's very important. Okay. In CPT beta, one question is to come from here, but now they are not asking, but yes, probability they might ask. So see, what is this? See, when you, example, like when you are attending online, if I make an offer, you can immediately listen to that, and if you say yes, I can also immediately listen to that. So there is no time lapse between me making offer and you understanding the offer. Similarly, you giving acceptance and I am understanding, I am acknowledging the acceptance. No time lapse. Immediately we are understanding. Same when you talk on call. But if you send letter of offer, if you are doing contracts through post by sending letters of offer, letter of acceptance through post, so now there is a time lapse. The day when I send you the letter, immediately you will not receive. When you send letter of acceptance, immediately I will not receive. There is a time lapse, and on the basis of this time lapse, ICA makes some question. What is the time lapse? Understand? Example, I am from Mumbai. I am a person who manufactures lungis. Okay, and Mr. V is in Bengaluru. So he is a wholesaler. I'm a manufacturer. So one day I send a letter of offer to him that I offer to sell you one lungi for 100 rupees. When did I send the letter? On 1st January. That letter reached, okay, Vishnu on 5th, and he read also on 5th. So he acknowledged about the offer on 5th. Now this guy posted letter of acceptance on 9th. I accept the offer. Okay, and that letter of acceptance reached me on 12th. So there are 4 days: 1st, 5th, 9th, and 12th. The question is, there are 4 questions which will come. Sir, when is communication of offer completed for Harsh? See, when can I say that I have communicated the offer? When I posted the offer letter. More than that, I cannot do anything. Yes or no? Basically, first check. When is communication of offer completed for Vishnu? When can Vishnu say ki, okay, the offer was communicated to me? Obviously, when he is acknowledged about the offer letter. Basically, when the offer letter reaches him, or when he reads it, whichever is later. Day when Vishnu received the letter of offer, 5th. Now comes to see, first and second was easy. Third and fourth is a bit tricky. When is communication of acceptance completed against Harsh? Now what is this? Sir, against Harsh, not for Harsh. Against Harsh means now the acceptance given, from which date the acceptance given by Vishnu goes against Harsh. Indirectly, from which date a contract is formed for Harsh. Okay, after this I cannot cancel my offer. Answer is the day when Vishnu posts the letter of acceptance. So, or my offer was made, I myself made the offer. The day when Vishnu posts the letter of acceptance. From that day, a contract is formed for me. After that, I cannot cancel the offer. Am I clear with this thing? Logic is there, I'll tell you. Because, understand, like me, many people might have made offer to Vishnu. Vishnu cancelled other people's offer and accepted my offer. Posted letter of acceptance. After this, if I tell him, or no, I don't want to go ahead with the contract. So it is, I don't want to go ahead with the offer. Okay, I want to cancel my offer. It is against him, no. That's a breach of contract. So basically, 9th is the day when contract is found for me. But 9th is the day when contract is found for me. But when is a contract formed for Vishnu? So when is communication of acceptance is completed against Vishnu? Now Vishnu cannot cancel his acceptance. Answer is the day when I acknowledge about the acceptance. Because after that I would have started my production. After that, can you say I don't want to go for the contract? No, that's a breach. That is 12th January, the day when letter of acceptance reaches or it is acknowledged by Harsh. Sir, if both the letter, like example, on 9th, he posted letter of acceptance. That letter reached on 12th. But sir, on 10th, he got a good offer from someone else. Now he want to cancel the letter of acceptance. He also cancel his acceptance. So he did speed post. And this speed post reached on 11th. And he told me, sir, my letter of acceptance you'll get, but don't treat it as accepted. I am cancelling it. So is it okay? Letter of revocation reached before letter of acceptance, fine. So there is no contract for him and neither for me. But example, sir, both the letter reached at the same time. Okay, so you have to take letter of revocation. You have to consider letter of revocation. There is no contract if both the letter reach at the same time. Am I clear at the same? Understood? Sir, am I clear? Everyone? Sure. Good. The unit 1 is completed. But in unit 1, but one important point is left. Now what is that important point? The important point is I'll write it here. If the main agreement is void, collateral agreement is valid. What does that mean? Understand. See. Example, Mr. X, Mr. Y. Mr. Y is a minor. He takes a loan from Mr. X. Okay, 1 lakh. But Mr. X is telling, okay, I'll give you a loan, but he also doesn't have money. So what he tells, he goes to Mr. Harsh and tells, sir, you give me 1 lakh rupees loan. I'll repay you after some time along with interest. Now, why? The reason is that Mr. Y will repay 1.2 lakhs. Mr. X told, sir, I'll repay 1.1 lakh. So 10,000 is profit, 10,000 Harsh profit. I told, okay, no problem. Now, Y did not pay. This is the main agreement between X and Y. And this is a collateral agreement between Harsh and X. If this main agreement is void, collateral is valid. So example, Y doesn't repay X. Can X file a suit on Y? Answer is no, not possible. But if X cannot sue Y, but can Harsh file a suit on X for repayment? Answer is yes. So what if 12 January 20 the letter of acceptance reaches in the morning and letter of revocation reaches in the evening, then what should we consider? See, then basically they will not give you question in that way. So in that case, but whichever letter he reads first, that will be considered. Am I clear with this thing? Okay, so practically there are two options actually, whichever he reads first, and second beta letter of revocation, okay, because both reach together. Okay, in such question beta, okay, it is you have to write whichever he reads first. Am I clear, Anish? Understood? Okay. Now this is the first thing. Now second, if the main agreement is illegal, collateral agreement is void. The example, I'll give examples. Mr. X is there, Mr. Y is there. Mr. X, Mr. Y wanted drugs. Mr. X told, okay, I'll sell you drugs for 1 lakh. Now Mr. X, what he was thinking, he will buy drugs for 80,000, he'll sell for 1 lakh, 20,000 profit, but he doesn't have 80,000. Goes to Harsh and says, give me 80,000 loan. I told, why? He said, I'll buy drugs. Mr. Y wants drugs. I'll buy drugs, sell it to him for 1 lakh. For 1 lakh. After 2 months, he'll pay me 1 lakh rupees. I'll pay you 90,000 rupees and 10,000 I'll give your profit, my profit. Okay, no problem. So this is the main agreement, selling drugs. This is collateral agreement. This main agreement is what beta? Void, valid, illegal. Illegal. So this collateral agreement will be void. See, example, Y doesn't pay X. Can X sue Y? No. Now beta, X doesn't pay me. Can I sue X? Answer is no. Because if I want to sue X, I have to tell the court, why did I give the loan? Can I tell I gave the loan because he wanted to buy drugs? No. That is also void. Because I cannot claim anything. Am I clear with this thing? Now people will be like, sir, if Harsh doesn't know about that, why he is taking loan, why X is taking loan, then it is not collateral. It's an independent contract. Then he can claim. Am I clear? Understood? The unit 1 is completed. If you understood, give me a thumbs up quickly. If you understood. Very good. Good. Now we'll be doing unit 2. That is consideration. Let us start with unit 2, consideration. Let us start. Anish, you understood? If you understood, give me a thumbs up quickly about that question's answer. Very good. Okay. I'll tell you what is consideration can be positive as well as negative. Don't worry. Now, what is unit 2? Unit 2. Unit 2 talks about consideration. Consideration means what? Something in return. We call it as quid pro quo. Quid pro quo. But something in return, basically. Now, again, this is understanding. Now, you don't get marks for understanding. I told you, you will get marks for writing definition, writing law. So, sir, how is a consideration defined? How is this word defined? I'll tell you. See, what is it? Consideration. How is this defined? When at the desire of promisor, the promisee or any other person has done something or abstain from done something, does something or abstains from doing something, promises to do or abstain from doing something, such act or abstinence is consideration for promise. So what is this? Let's understand. When at the desire of promisor, if I tell you to do something, what is the consideration for me? If I tell you to do something and then beta you did that thing for me, then it is a consideration for me. If you did something voluntarily for me, okay, then beta will it be a consideration for me? No. So do I owe a consideration to you? Like you, I told you sell me the goods, I'll pay you 100 rupees. Then you sold me goods, it is a consideration. But on my birthday, beta, you came and gave me something gift and you're telling, give me more money. So is it a consideration for me? Well, no, obviously not. It is not a consideration. Can you claim money from me? No, because it was not at my desire. Yes or no? So when at the desire of the promiser, the promisee or any other person, you or on your behalf, someone has done something for me or not doing something for me. Not doing is also a consideration. Is doing something for me or not doing for me. Promises to do or not to do something for me. Thus doing or not doing is a consideration for me. Am I clear with this thing? Understood properly? Consideration for the promiser. Clear everyone? Understood? So can I understand from this? See, consideration can be past, present as well as future. You've done something, you're doing something, you have promised to do. Both, all three are consideration for me. Now we studied beta, there are some rules of offer, we did that. There were some rules of acceptance, we also did that. Similarly, there would be some rules of consideration. Can we do them? No, obviously not. So let us start with rules of consideration. First three rules are there basically in the definition only. Okay. See, consideration must move at the desire of promisor. It should move at the desire of promisor. Now that is the first line. When at the desire of promisor. So if I told you to do something and then you did, it's a consideration for me. Correct? For that beta, case law is there. Durga Prasad versus Baldev. In this case, Mr. Harsh, I am the district collector. Ms. Suman is the builder, and the whole class people are hawkers. So what happens beta? Hawker means people who sell stuffs on road. What happens? You create a lot of traffic. What happened here? Okay. You create lot of traffic. Okay. So what I saw is there is an open land. Okay. So I called Suman a builder and told you do one thing, you build a market for these hawkers and allot shops to them. Okay. They will pay you rupees 1 lakh for a shop, or they will give you commission on their sale. The contract was between me and Suman. Okay. Suman was like, okay, no problem, I'll do it for them. Now she built the market and then she started claiming 1 lakh rupees from the hawker. Okay. Now hawkers did not pay her any money. She's like, Are, I gave you a consideration, I built the market for you, okay, you owe me a consideration, 1 lakh or basically commission. Basically, are the hawkers bound to pay that? No. Because the market which she built for the hawker, is it a consideration for hawkers? No. Because did they tell her to build? No. So basically, okay, so she did not give any consideration to them, she can't owe. Now you will be like, sir, it is her loss. No, it's not her loss. You can't claim anything from the hawkers, but obviously she can't even, she will not even allot the shops to them. Simple as that. Am I clear? So Suman built the market and claimed 1 lakh from hawkers. Hawkers refused to pay. Can Suman sue the hawkers? Answer is no. Clear? Okay. Then consideration can move from promisee or from any other person. Second line. If I do something for you, if I tell you to do something for me and you have done, or on your behalf you told someone to do something for me, but contract was between me, is it a consideration for me? Yes. I am bound to give you consideration. Okay. Like I claim loan from you, give me a loan of 1 lakh, I'll repay after 1 month. You told your spouse, okay, transfer 1 lakh to his account. Did I receive consideration? Yes. On due date, if I don't pay, can you sue me? Yes. Can I say, oh, you did not repay, you did not give me loan, your spouse gave me the loan, so he or she will sue me, you're not you. Obviously, the contract was between us. So basically, you only can sue me. So see, case law, Chinnaya versus Ramaya. There was a lady, Mrs. A. She was very old. She was about to die. She had a property of 100 crores. Now, after her death, this 100 crores will be divided into between two people. 50 crore to B, who was the daughter of A, and 50 crore to C, who was brother of A. But what, he had a bad habit. He was a drunkard. So what A thought, that boss, if I give 50% property to C, he will sell it and, or he'll make 50% of property a bar. So what she did, but she wanted, she loved her brother. She wanted to ensure his existence. So what she did, she told Miss B, do one thing. Rather than 50 crore ka property, I'll give you entire 1 crore, 100 crores ka property. The whole property I'll give it to you. She's like, thank you. The thank you. You have to enter into a contract with B, okay, and promise B that you will pay 1 lakh rupees monthly to him. So she's like, okay, I'll do it. But no, enter into contract. So B entered into contract with C. B was the promiser and she promised to pay 1 lakh rupees per month to C. Now, A died. After a month, C came to take that 1 lakh. Now A told ki, uncle, you can't claim 1 lakh from me. So why? See, as per the contract act, consideration should go from both the parties. I am paying you 1 lakh. What did you give me? You did not give me any consideration. So it's not a contract. Is there a contract? Yes. Because consideration may move from promisee. Promisee did not give anything. Or any other person. Who's this any other person? A. Did she give consideration to B? Yes. That 50 crore extra property. We got a consideration. And she is bound to pay 1 lakh rupees to C. That is Chinnaya versus Ramaya. Am I clear? Understood? Understood? Two things. Then third point. Consideration can be past, present and we studied na? When at the desire of promiser, the promisee or any other person has done something, promises to do something or not to do something. Consideration can be past, present and future. Okay. Consideration can be executed or executory. What is executed? Past. Executory, present and future. Simple. Consideration can be positive as well as negative. On YouTube one's question was asked, what is positive and negative? Positive means to do something, negative means not to do something. Okay. Consideration need not be adequate. Very important. See, consideration need not be adequate. See, consideration decided by both the parties out of free consent will be a valid consideration. It may be equal to the market value of goods. It may be more than the market value of goods. It may be less than the market value of goods. But if consideration is decided by free consent, no coercion, no undue influence, no fraud, okay, then beta it is a valid consideration, okay, it is a valid contract. Later on beta the parties cannot change, any one party cannot say it was less than the market value, I want to get, there was no contract, okay, so give my stuffs back. No, consideration decided by parties with free consent shall be final even if it is inadequate. Am I clear? Yes. Consideration must be real and not illusory. Like example, yeah, I told you, can a consideration be illusory? Give me 1 crore, I'll make a machine. Or forget a machine. Give me 1 crore rupees, I'll bring stars on earth, on land. Is it a consideration? No, it is illusion. Nobody can bring. And even if I bring, but will you be alive to see that? No, this cannot be a consideration. Hence, consideration must not be immoral or against public policy. Like, I am going to retire as a government servant, and I can nominate anyone, okay, to take my job position. I tell ki anyone who pays me 1 crore rupees, okay, will get the job, my job. Selling better government jobs, is it a consideration? It's not a consideration. It's not a valid consideration because it is against public policy. Am I clear with this thing? Anyways, this law is not there now. Initially, beta, okay, you had the option to give your job to someone, but now, beta, this option is not there because of this frauds only. Beta, okay, government stop that. Am I clear? Understood? Next, consideration for an act which a person is legally bound to perform is not a valid consideration. Like I told you that I will do something for you, you give me you make payment, but whatever I'm going to do for you, it's my legal duty to do. So did I give any consideration to you? No. So I cannot claim any consideration from you as well. Sir, can you tell me an example? Yes. So see, I'll give you an example. There is a company, ABC Shipping Company. Okay, and they are into the business of sailing passengers from one place to another, tours and tourism kind of. So they have one ship, okay? That ship now currently is in Sri Lanka. Okay? Now there are only two people who can sail the ship. It's very technologically advanced ship. One is their captain, one is her sir. Okay? So what happened? Their captain is now there. He felt sick in Sri Lanka. So ABC Shipping Company contacted me. I'm not their employee. I'm an individual, separate, freelancer. So they told me, okay, can you sail the ship? I told, okay, I'll sail the ship back to Mumbai. That is my duty. Okay, but under the contract, but I'll charge 1 lakh. Well, okay, we'll pay you 1 lakh and you sail the ship. Okay, so my legal duty is to sail the ship to Mumbai for 1 lakh. We reached Goa, beta. Now, Goa, beta, there was a halt of 5 hours because of high tides. Now, in Goa, na, I went to play casinos and all, and I lost all my money. I'm like, Arey yaar, now my wife will kill me. I'm like, I called from Goa, okay, ABC Shipping Company, and I told I want 2 lakh rupees, not 1 lakh. They said, Arey sir, you told 1 lakh, so we agreed. No, I want 2 lakhs, or I'm throwing the keys in the water and I'm going. So they told, okay, sir, we'll pay 2 lakhs. Said, thank you. So we sailed to Mumbai, abroad, and now ABC company paid me 1 lakh rupees only. I'm like, no, you told 2 lakhs, now we had an offer and acceptance. They told we'll pay 1 lakh. Can Harsh sue for 2 lakhs? Answer is no. Because tell me, first contract was done, and what was my legal duty to do? To sail the ship to Mumbai for 1 lakh. That was my legal duty. Now, but I am claiming 2 lakh. Did I give any extra consideration? No. I just performed that thing which was my legal duty to do. I did not give any extra consideration. So I cannot claim any extra consideration. Am I clear with this? Understood properly? Clear? Yes. Good. Sure. Perfect. So we understood, okay, what is consideration and rules of consideration. Now we will be studying this one. Privity of contract. Important point comes in exam. Privity of contract means what, beta? Privacy of contract. Like, no, you don't like anybody affecting your privacy, interfering in your privacy. Same thing, beta. Take a contract tells boss. Take only parties to contract. Okay, can interfere in the privacy. What does that mean, sir? There is a tagline for this. Stranger to contract cannot sue. That means, beta, people who, what is this? Who's a stranger? Stranger means a person who is not a party to contract. Only parties to contract can sue each other. Stranger to contract cannot sue. Am I clear? A person who is not a party to the contract cannot sue the parties. Let's take an example. See, Mr. G took a loan of 1 lakh from Harsh and fails to repay. Can Harsh file a suit on G? Answer is yes. Party to contract. But can S, friend of Harsh, file a suit on G? Answer is no, as S is a stranger to contract. Clear, everyone? Only parties to contract can sue each other. Strangers to contract cannot. But beta, there are some exceptions. Now, what are these exceptions? That means, beta, there are exceptions to the rule stranger to contract cannot sue. That means in these situations which I am telling you, even if a person who is stranger to contract has a right to sue. Okay, so which are these exceptions? Let's understand. First, beneficiary under a trust. What is the first one, beta? Beneficiary in case of trust. Let's take an example. See, there is a person. His name is DP. Why I wrote DP, I don't know. Okay. Dharmendra Prasad, example. Okay. What happens? He's a rich guy, but he's not well. Anything can happen. So what he does, after his death, whole property will go to his son. His son, DP's son, is Chotu. But Chotu is only 8 years old. Can he handle the properties? No, sir. So what DP did, he appointed a trustee to handle his property after his death through a trust deed. So trust deed is a contract. So DP is called as author, Harsh is called as trustee. And basically it is written until majority of DP's son, property will be with Harsh. Am I clear with this? Understood? Okay, now DP died. Now I should have used the property for whose benefit? Chotu's property. I started misapplying the property. All the rent and all I am taking. Chotu understood this thing. Now Chotu is like, uncle, you are doing wrong. But yes, I am doing wrong. But I am committing a breach of contract. But it is DP who has to sue me. DP is dead. You also removed DP's DP. Yes or no? Basically is dead. He can't sue me. So obviously only he had the right to sue me. You can't sue me. You are stranger to contract. Then Chotu file a suit. Answer is yes. Chotu can definitely sue. The reason is that, beta, the purpose of the trust was to give benefit to Chotu. If Chotu is not getting the benefit, what is the use of that contract? So even though Chotu is stranger to contract, he has a right to sue. Am I clear? Understood? Next, written family arrangements. What is this written family arrangements? Let's understand. Sir, written family arrangement. See, what is this? DP is there. Again, DP came. DP had 2 sons, Latif and Meet. But DP died. His role was this much only. Now, what happened? After his death, Latif and Meet, they both entered into a contract to divide the properties between them. 50% of property Latif will take, 50% of property Meet will take. But before division of Meet, before division of the properties, contract was done, signed. But actual division of the properties, Meet died. Now Latif decided to take all the properties. And he was taking all the property. This is wrong, no? He is committing breach. Meet had a wife. Her name is Nagavalli. She is like, you're wrong, you're doing wrong, Latif. He's like, yes, I'm committing a breach of contract, but it's only Meet who can sue. He's dead. Okay. So nobody can do anything. Can Nagavalli file a suit? Answer is yes, even though she is a stranger to contract. Am I clear? Yes. Understood properly. Good. Third, marriage settlements or agreements. Now, what is this? Sir, any contract on the basis of which marriages are settled. These terms can also be enforced by a person who is stranger to contract. Let's take an example. What is this? Example, DP is the DP. DP's son is Meet. Meet married Nagavalli. DP is telling, don't marry her. She's Nagavalli. Then too he is married. Love is blind. He's like, she'll destroy your life. Like, no, I love her. He married. For 2 months she was good. After 2 months she justified her name. Started beating him like anything. She beated him like hell. His face changed. One day he ran to DP, his father. Father also did not recognize him. So he told her, I am your son. Then his father recognized. Father told, I told you, na, don't go to her. You went. Now see what happened. It'll take half an hour. Okay, sorry. So now what happened? Okay. Meet went to DP. Now Nagavalli for 15 days she did not do anything. But after 15 days she started missing him. So she went to DP and told me, I want my husband back. So DP is like, you know, I will not give my son back to you. I know what you will do. She's like, I'll not do anything. I realized my mistake. So DP told, okay, I'll send my son back to you, but condition is that you have to enter into a contract with me. And in that contract, it is written that tomorrow if you touch Meet again, you have to pay 1 crore rupees compensation to Meet. Nagal is like, okay, she signed the contract. Since for 6 months, everything was proper. She was taking care of me. Now DP thought, ki, okay, Nagavali changed. I have to say thank you to God. So he's like, okay, I'll go to all the temples, big temples in India to say thank you to God, which will take 2 months. And he left. After he left, but Nagavali understood, oh, he left now. She again started justifying her name. She hit Meet. He's like, hey, my dad will sue you. You have to pay 1 crore rupees to me. He's like, Are, your dad will come after 2 months. Until that, you should be alive, no? Like, I'll sue you. So you can't sue me. Because it is me and DP, your father, who have entered into contract. You are third party. You are a stranger. You can't sue. Can Meet sue? Answer is yes. Even though he is stranger to the contract. Because he is the person who is suffering now. So he has a right to sue. Am I clear with this thing? Yes. Okay. Next is assignment of contract. Next exception. Assignment means what, beta? Transfer. Now let's take an example. Guys, there is a guy called as Vijay Mallya. Very famous person, very innocent person, correct? He took loan from SBI. Okay, of only 9,000 crores. And he left. Never came back. Now who signed or who accorded the loan? Who gave consent to the loan? Who allowed the loan indirectly? It is the CEO of SBI. And he is my friend. Now what happened now? My friend was very worried. Day night, he was worried because people are putting allegation that he did not do his work properly. So I can't see my friend like this. So what I did, I had a talk with SBI and I told you, okay, you're facing a loss of 9,000 crore. I will pay that 9,000 crore. Chalo. I paid 9,000 crores to SBI. Now I went London. I found Vijay Mallya. I'm like, hey Vijay Mallya, come sit. Sir, don't pay the loan. Huh? I'll file a suit. I'll file a suit on you. Like, who the hell are you? I'm like, Arey, I'm Harsh. I repaid your loan. He will be like, did I tell it to you? Can I sue Vijay Mallya? No. Contract was between Vijay Mallya and SBI. But do you think, beta, randomly I'll give beta 9,000 crores? No, obviously not. What I did, I paid 9,000 crore to SBI and I told SBI, boss, you got 9,000 crore, no? So now transfer the whole contract to me. So now I come in the place of SBI. Now on assignment, can I file a suit on Vijay Mallya? Answer is yes. If he tells me, who the hell are you? I tell him, come here, I'll tell you who am I. Answer is yes. So even though I was stranger to contract, first, okay, can I file a suit now? Answer is yes. Am I clear? Very good. Next is acknowledgement of debts. Now what is this? Let's understand. It's a good point. Huh? Example, Miss Nikita took loan from Mr. Prashant of 1 lakh rupees and I told I'll repay after 6 months. She's a woman of words. After 6 months, when the due date was coming closer, she understood I have to pay, but at that time she was not having money. What did she did? She had a property. She sold the property to me. To whom, beta? To me. And then, okay, I told her, why are you selling the property? Just now you purchased. She told me, I have to repay the loan. Okay. And I have to fly to US. Okay. So I don't have money, so I am repaying the loan. So I told, Acha, do one thing now. We had a contract. You sell the property to me. Okay. I purchase the property. But whatever loan, okay, you have to pay to Prashant. I will repay your loan. You be free. So she's like, okay, no problem. So there was a contract between Harsh and Nikita that boss, okay, Harsh will repay the loan to Prashant. Does Prashant know about this thing? No. So on due date, Prashant came to claim 1 lakh rupees from Nikita. Nikita told, no, I will not pay. Harsh will pay. We have a contract. Prashant claimed the payment from Harsh. Boss, Harsh told, I don't have money. I can't pay. Can Prashant sue Harsh? Answer is no, because contract was between me and him, me and Nikita, that I'll repay. Did I contact to Prashant? Answer is no. So Prashant is a stranger to contract. But what Nikita did, if the question changes, Nikita told, okay, we'll do this thing arrangement, but first you have to inform Prashant that boss, you will repay his loan. You will repay my loan to him. I informed him. Now, beta, is Prashant acknowledged of the fact? Now, beta, if I don't pay him, can Prashant file a suit? Even though he was stranger to contract. Am I clear with this? Understood? Clear? Good. Next is covenants with land. Now, what do you mean by covenants? Covenants means conditions during sale of land. And this is actually a good point. It tells that, sir, the conditions during sale of land, Like if I sell the land to you subject to some condition, that conditions I can enforce and even my successor can enforce, even though they are not, they are stranger to contracts. Even my successors can enforce it. I'll give an example of this here. Example, there is a land of mine. I sold this land to Dimple, but there is a temple on this land. So basically, there is a condition that boss Dimple will not demolish this temple, and every year once, okay, I and my family will come. You have to allow us to offer prayers. This is the god of the land. I told yes. Until I was alive, she allowed it. But after my death, she told my successors, okay, sorry, I can't allow. My successors are like, are you committing a breach of contract? Like, yes, I am committing breach. But it is who has to sue? Like, your father. Your father is no more. Basically, you can't sue. You are stranger to contract. Can my successor sue her? Sir, yes. Am I clear with this? Next, contracts my agents. Principal can sue on contracts entered by agents on his behalf. Now see, I appointed you as my agent. I'm the principal, you are my agent. So if my agent is selling goods on my behalf, who's the owner of the goods? I am the owner of the goods. You are just acting on my behalf. Yes or no? So here, what is written? Example, Harsh. I was a person who was manufacturing alcohol and selling alcohol. But for selling now, I appointed a person called as Tanu. Okay. Tanu is my agent to sell alcohol. One day, Tanu entered into a contract with Mr. Mohan. Okay, that Mohan will buy the alcohol and he'll pay after 2 months. The contract was between Mohan and Tanu. He gave the alcohol, Mohan failed to pay. I understood the fact. I sent notice to Mohan, sir, you pay the payment or I'll sue you. Mohan is like, who the hell are you? I entered into contract with Tanu. So Tanu should file a suit. You are stranger to the contract, you cannot sue. Tell me, can I file a suit? Answer is yes. Because it is actually my goods. I am the main person. My agent, Tanu is just a shadow of mine. So even though I am stranger to contract, I have a right to file a suit. Am I clear with this? Understood properly? Clear? Yes? Okay. 2 minutes break I am giving you. Okay, as I promised. After every 1 hour, 10 minutes, 15 minutes, I'll give you 5 minutes break. The 2 minutes break I am giving you. We'll finish this part now, unit 2, and then we'll take half an hour break. Okay? 2 minutes break. Now am I audible? Now am I audible? Okay. Now I think I'm audible. ठीक है. अरे I switched it on यार. Why? ठीक है. My bad. No consideration, no contract. If there is no two-side consideration, will it be a contract? No. Correct. This is true. But is this statement absolute? Answer is no. It's not absolute. Okay. There are exceptions. So now we'll be studying the exceptions to no consideration, no contract. Okay, because all circumstances will not be same, so you cannot apply one law for all the circumstances. So sir, in this situation which we will discuss, even if there is consideration from one party, then too it's a contract. Am I clear? Or if one party is promised to give consideration, it is a contract. See, first is agreement in writing between parties who are standing in close relation to each other, made out of natural love and affection, and registered under that. If all these four conditions are fulfilled, then it is a contract. Let's take an example. I'll give you examples here. There was Mr. X. He had a daughter. Okay. Miss Y. And he made a agreement in writing. She turned 18. So he wrote, out of my natural love and affection, I am telling that boss, okay, after my death, all my properties will go to my daughter, no one else. Okay. So he signed, daughter signed. Now they had to register this agreement. So they went for registration. Now what happened? Now before registration, okay, X died. They met with an accident. X died. Okay. Now after his death, Y is claiming the entire property. But all the other family members like ex-wife, okay, and basically his sons, they are telling the property should be divided amongst everyone. Why is like, no, it is written, if the property will come to me, no one else. So who will win? Why will win, or the other family members will win the matter? Other family members. Because boss, see, writing, it was in writing, between parties standing in close relation, out of natural love affection. But was it registered? No, before registration only X died. So now beta, that agreement is just an agreement, it is not a contract. But after registration, if he died, then beta, yes, then beta Y can claim the whole property. Am I clear? Yes. Next, promise to pay compensation for past voluntary services. Beta, because of this point, beta, in India, past consideration is also consideration. Now see, example, Mr. Harsh, I lost my wallet. Okay. And Nora Fateh found it and gave the wallet to me. While giving the wallet, she told me, I found your wallet, give me 1000 rupees. Can she claim it? No, she did it voluntary. It's a voluntary service, she can't. But example, she found it, she gave the wallet, and I voluntarily told, I'm very happy if you gave me the wallet. Please come tomorrow, say this same place, I'll give you 5000 rupees. Yes, I want to compensate you for that. I want to pay you 5000. Now beta, see, I promised to pay compensation for the voluntary services which she gave me. Now beta, it is a contract. Now I'm bound to pay beta that 1 lakh rupees. Sorry, 5000 rupees. If I don't pay 5000 now she can sue me. Am I clear with this thing? So voluntarily she can't ask anything. But in case I don't pay her the money now, after promising, now it's a contract. Okay, I am bound to pay. It's a contract now. Am I clear with this thing? Now I cannot refrain from my statement. Did you understand? Okay. Next is promise in writing to pay debts barred by limitation. Now what is the meaning of barred? Barred means stopped. Now limitation means limitation act. Now let's understand, it's an interesting point. Okay. See, one day Harsh took a loan from Miss or Mr. Okay, Sushant. Okay. On 1st April 2021. and I told I'll repay on 31st December 2021. Now I did not repay. Now basically Sushant has a right to file a suit on me, but he should file a suit on me beta within 3 years, that is by 31st December 24. That is limitation period, because law tells ki boss, in case something happened wrong with you, you have to come to the court as soon as possible. For that beta 3 years is given. If he fails to sue me within 3 years, beta the contract dissolves. It is assumed that beta no contract existed, I did not take any loan. Am I clear? Now beta, actually Sushant failed to sue me within 3 years, that is by 31st December 24. Now after 4 months of that, 1st April 25, I met him, and basically I myself gave in writing that okay, you did not sue me, I'll pay that amount to you, don't worry. Now beta, that debt was dead, but by voluntary giving in writing now that was I'll pay that debt, I again beta brought that dead debt into life. Now beta, it's a contract. Now if I don't pay him beta, okay, can this guy sue me? Answer is yes. Now if Harsh fails, now Sushant can sue me within 3 years again that 3 years period will start. Now can I say, oh, what did you give me? I'm the voluntary doing it. No boss, by voluntary, I understand you did it voluntary, but boss, by doing that, you again brought that dead debt into life. So now beta, I'm bound to pay. Am I clear with this thing? Yes. Okay. Now what is the next point? Agency. Sir, if I appoint you as an agent without consideration, without commission, will you act as my agent? Answer is no, not possible. And why will you act? Simple. So sir, why is it written agency here? No consideration, no contract exception. Why is agency coming here? I'll tell you the reason. See, in India there are many laws, LAWS laws, which tell that between two people there is a agency relation, principal agent relation without consideration. Like take an example, like under Partnership Act. You have studied Partnership Act, obviously. Take care. Under Partnership Act, one partner is the agent of another partner. Yes or no? But do they pay commission to each other for acting as agent? No. They're agents without consideration. Similarly, as per Indian Contract Act only, special contracts I'll teach you. Husband and wife. Wife is the agent of husband for necessaries of life. So if my wife purchases some necessaries of life, okay, food grains and all, and tells the shopkeeper my husband will pay, it is assumed that I have purchased it and I am bound to pay. So she's an agent, but am I paying commission to her for that? No. So there is agency without consideration. Am I clear? Next, completed gifts. Now what is completed gifts? See. Sir, promise to give you a gift is not a contract. I promise that I'll give you a gift on your birthday and I did not give. Can you sue me? No, obviously not. But this is not gifts, this is completed gifts. If I give you a gift and you accepted it, now it is a contract, but now I cannot take back the gift. Okay, did you understand the difference? It is completed gifts, not take a gifts. Am I clear? Okay, so see, promise to give a gift is not a contract, but once a gift is given, it cannot be taken back. Like example, if I promise my wife that I'll give her a Audi car on her birthday and I did not give her, can she sue me? No. But if I gave the Audi car to her and basically she accepted that, now can I take it back? No. Like you people, you do not break up. When you do break up, you say okay, my gifts are that, give my gifts back. No, you cannot take it. It is a contract, you cannot take it. No. Okay. Now, charity. Now people have this question, sir, why you can't take it back? It's a beautiful reason behind that. It is for avoiding fraud. Okay, but this is crash course, so I'm not taking it completely. I can't take it obviously. So just the provisions I'm telling. Now charity. Sir, if I tell you I will give charity to a temple, to a mosque or to a church and I fail to do it, can they sue me? No. But sir, then why charity is here? Beta, see, understand. Promise to do charity is not a contract. Yes, I can. If I don't give the charity, okay, you can't sue me. But example, on the basis of my promise, if the other person, okay, incurs any liability, okay, then I am liable for that liability undertaken. Like example, if I tell a temple to give charity of 1 lakh rupees to you, so the priest asked me, sir, should I do repair? Should I start some repairing work on the basis of this promise? I don't know. Okay, start the repairing work. Now I do not give charity of 1 lakh, but he has already incurred 40,000 rupees on the basis liability on the basis of my promise. I'll be liable for that 40,000. Am I clear? There it is a contract. The promise to give charity is not a contract. However, if the promise he has undertaken, liability on the promise of promiser, such promiser is liable to pay for the liability undertaken. Am I clear with this? Understood properly? Clear? So here unit 2 comes to an end. Understood? Chalo. Okay. So we'll take a break of half an hour now. Okay. And then we will continue. Okay. So it is 10:35 on. We'll start at 11:05. Okay. Half an hour break. Okay, so guys, unit 2 is done. Sir, this bailment we have not done. Arey but don't worry, bailment you have a separate unit altogether for bailment. That will do. So we'll do now. We'll continue. I'll go with unit 3. Unit 3 is other essential elements of valid contract. Okay, I told you unit 1, 2, 3 will tell you how a contract is formed. Unit 1 talks about offer acceptance, unit 2 talks about consideration. Unit 3 talks about other essential elements of valid contract. In that beta, first is capacity to contract, this you will do. Then free consent is there. Then unlawful object and consideration. Then agreements which are declared void by the law. Am I clear? These all things we will be covering. Let's start. Sir, capacity to contract. Parties should be having capacity to enter into contract. Yes or no? That means party should not be a minor, should not be of unsound mind. Okay. And party should not be disqualified by law. But sir, what if I enter into an agreement with minor? So that agreement is void ab initio, that is void from the beginning itself. Case law for that is Mohiri Bibi versus Dharmodas Bose. What happened in this case? Mr. A minor, he took loan of 20,000 from B, a major, and pledged his house and failed to repay the loan. The question is, can major take that house? No. Agreement with minor is void ab initio. You cannot take the pledge. You cannot take the house. Sorry. So Mr. B told, okay, then do one thing, give me the loan back. Answer is no. You will not neither get the loan back, neither you will get the house. Okay, that was the decision. Understood? Because if you take the loan back, court tells you to take the loan back, then beta court is telling that the contract is valid. Yes or no? Repayment of loan ban jayega wo. That's the reason. Now, second, minor is not liable on contracts. Understood? But is minor liable on contracts undertaken by his guardian? If my guardian, I am the minor, my parent takes a contract on my behalf. So answer is beta, that contract will be liable for, or that contract is valid for the minor only if the contract is reaping benefits to the minor. If minor has to undertake any liability, do something to perform the contract, then the agreement is void. Like example, can my dad buy an immovable property on my behalf? Answer is no. Because here from my funds beta payment will go. I am liable to make payment. So it is void. Okay. But can my dad sell immovable property on my behalf? Answer is because I am just getting money. It's only for my benefit. Am I clear? Minor is not liable on the contract. Minor is also not liable on the contracts undertaken by guardian where minor incurs liability. Sir, but if a minor enters into an agreement and he doesn't fulfill, is a parent or guardian liable on that? Answer is no. Parent or guardian are not liable for agreements entered into by minor. Why will they be liable? They are two separate persons. Next is minor can plead minority. Now what do you mean by that? Like example, there is a person, Mr. X. He comes to me. I am a person who sells mobile. I know this guy, but I don't know his age. He stays in my building. He tells me, sir, it is my 20th birthday, so I want a mobile, but I'll pay you after 2 months. So, well, okay, no problem. I gave the phone. iPhone. Now, Mr. X fails to pay. Now, when I file a suit, Tika is like, Uncle, I'm so sorry, I'm just 17 years old. And he was actually 17 years old. As a minor. Can he plead minority? Answer is yes. I cannot sue him. Even though he lied. Understood? Okay. So that is nothing but law of estoppel does not apply to minor. Okay, he cannot be stopped from denying the fact that he lied. He is a minor, he can do anything. Next is no ratification of contracts allowed on attaining majority. Minor's agreement cannot be ratified, beta. Ratify means approved. Like example, I am 16 years old and I took loan. Example, I am not 16. I am 16 years old, but I took loan for 3 years. Now while repayment I am 19 years old, major. So am I bound to repay? Can the creditors force me to accept the contract? Answer is no. Basically, agreement with minor is void ab initio. It was void from the beginning stage itself. So minor's agreement cannot be ratified. Okay. Next, minor cannot be declared insolvent. Why, sir? Sir, insolvent means a person whose liabilities are more than his assets. Minor will never take liability. So minor cannot be declared insolvent. Next. Sir, minor cannot be a partner in a partnership form. Why? Because entering into a partnership is nothing but entering into contract. The minor cannot enter into contract, but can he be admitted for benefits of partnership? Yes. Okay. Minor's estate is liable for necessaries supplied to him. Very important. Sir, example, I am Harsh. I found a minor on road. I want to study. I want to go to school. So basically, I provided him education, food. Again, he stayed with me. So all these are necessaries of life. Clothing. Now, after some years, he became a chartered accountant. Now, and he's like, sir, I became chartered because of you. Thank you so much. I got 25 lakhs package. But very good. Okay, you have to pay me 28 lakhs something from first day till today. Okay, I have expended so many things. Okay, so much amount. 28 lakhs. Okay, please pay me. Okay, or else I'll sue you. Can I sue him? Minor is not personally liable for necessaries. But example, he has a property. His father had a property. Example, we found that his father had a property. Now he has that property. Can I sell his property and take that amount? Answer is yes. A minor's estate can be made liable. Understood? My friend's son is a minor. My friend is no more. He doesn't have anyone. Okay, so I provided necessaries to him, to minor, my friend's son. Later I cannot sue him personally for the expenses, but from his property, my friend's property, I can sell my friend's property and basically recover that amount. That right I have. Am I clear? Next. Yes, can a minor be a shareholder? Answer, beta. Minor, actually, as per Companies Act, minor cannot be a shareholder. But how it is written in Contract Act, minor can be a shareholder. But condition is that transfer deed, contract to buy the shares, should be signed by the guardian, minor's guardian. And the shares should be fully paid. Partly paid shares hai, so basically company will not give membership to minor. Am I clear with this thing? Okay. So two conditions, then he can be a member. First, shares should be fully paid. Partly shares not allowed. And transferred it should be signed by guardian. Okay. Next, minor is not liable for torts. Now what is torts? Beta, civil wrong. See, only under breach of contract he is not liable under Indian Contract Act. But apart from that, he might do many civil wrongs, like example, riding without license, traveling without tickets. For that he will be liable. That is tort, civil wrong. So for civil wrong, minor will be liable. Okay, like if you are driving without license, if the police catches, don't tell him, oh, uncle, I'm minor, you can't do anything. He will do it. You have to pay fine. Am I clear with this thing? Clear, everyone? Yes. So, good. Then who will take the blame, sir, if a minor pleads minor? Nobody. It is loss of the third party. No blame game here. Minor hai na, nothing. But if he has that mobile, I can take the mobile back. That right I have. I'll take the mobile back if he doesn't pay. Now, section 12. Sir, you will give minor's agreement understood. But sir, what if I enter into an agreement with a person of unsound mind? That is also void ab initio, void from the beginning. But sir, what if a person is of unsound mind only in intervals? Like some people are drunkard and they are not drunk, they are sane. When they are drunk, boss. They are insane, square. Yes or no? So, sir, in case I enter into contract with the drunkard, okay, whether the contract will be valid or void, okay, it depends upon when did I enter into contract. Sir, in case I entered into contract when he was drunk, then beta agreement will be void. But when he was not drunk, so basically it will be valid. Am I clear? Next, persons disqualified by law. Sir, these are the people who cannot enter into agreement in India, cannot enter into contracts. Okay, agreement means contracts. First is alien enemies. Okay, I told you who's alien enemy. Okay, a person who's a citizen of a country with which India has declared war. Can he enter into contract with Indians? No. Insolvent, a person whose liabilities are more than assets, cannot enter into contract. He can't pay current liabilities. When he enters into contract, if any liability arises, will he be able to pay? Impossible. Company. Sir, can't company enter into contracts? We have seen companies entering into contracts. Yes, but companies can enter into contract, but under Companies Act we studied MOA, Memorandum of Association Object Clause. So they can only undertake those activities, those contracts which are mentioned in the object clause. Anything not mentioned in the object clause is ultra vires, void ab initio. Yes or no? Company can undertake contract which are within the powers of MOA only. Convicts. Convicts means what? Beta, people who are in imprisonment. Jail. Okay, can they enter into contract? Answer is no. Foreign souvenirs, diplomats. Example, beta, Joe Biden, Donald Trump. Okay, they cannot enter into contract. It's like, is it like that? No. See, what the Indian Contract Act says, these people will enter into contract and can enter. But in case they don't perform the contract, can we sue them? No, because friendly relations will get affected. We can sue them only if central government allows. This is written, but practically it doesn't happen like that. Practically what happened in law of agency, I'll tell you. Understood? So basically when we file a suit on them, at that time they are incompetent to contract. Like minors, so we can't sue them. Am I clear with this thing? If they sue us, we can file a cross suit. That is allowed. Okay. So this is capacity to contract. We studied beta. Party should not be a minor, should not be a concerned man, should not be declared, should not be declared disqualified by law. Am I clear with this? Understood? Okay. So, sir, the next is free consent. I told you guys, that parties to the contract, people who are parties to the contract, there should be offer and acceptance. Acceptance means giving consent. So basically, law doesn't want consent. Law wants free consent. What do you mean by free consent? Consent without flaws. Consent without flaws. These are the 5 flaws. If you say yes to the contract, yes to the offer, then beta, it will not be a valid contract because it is not valid acceptance. So which are the 5 flaws? Let us understand. Coercion, section 15. Now what is coercion? Like putting a gun on someone, sign the contract, or slapping someone, sign the contract, or kidnapping someone's family members and telling sign the contract, okay, or else I'll not leave this person, or threatening to do all these things so that the person should enter into contract. All this is coercion. Coercion, physical harm is involved. Okay, so basically it is not valid. Okay, the contract is voidable. Okay, now but in coercion generally physical harm is there, but one type of harm is there which is a mental harm, but that is coercion, that is threatening to commit suicide. Like example, you might have seen in old movies, okay, the hero loves the heroine and she's not ready, okay, she's not ready to accept his marriage proposal and all. So what he does, okay, I'll die for you, yes or no? He'll go to the terrace and he's like, he say yes, okay, accept my offer or else I'll die, yes or no? And then the heroine, she says yes. Nonsense, that is coercion. Am I clear with this thing? It's a voidable contract. Okay, to see. Coercion, committing or threatening to commit an act forbidden by Indian Penal Code. Physical harm is involved. Threatening to commit suicide is also coercion. Place of occurrence of the act is immaterial. Like example, I wanted to buy your property in Mumbai, but me and you, we were in Singapore. Okay? In Singapore, I had put a gun on you and I told you sign the contract to sell your property. Now, beta, I did it in Singapore. There, Indian Penal Code doesn't apply, because what is coercion? Committing an act which is punishable under Indian Penal Code, or threatening to commit an act. But beta, in Singapore, Indian Penal Code doesn't apply. But what I did, will it be coercion or not? Yes, it is coercion. So consequences contract is voidable. Am I clear? Yes, good. Next is undue influence. Undue influence. Now, what is undue influence? See, if you are telling me this guy did undue influence against me and I told yes to the contract, let the contract be voidable. Here also contract is voidable. Okay. So there are two things which you have to prove. There is a formula. Both the things should be there. So there would be undue influence or else not. One party is in a dominant position. What do you mean by dominant position? Position to affect the will of another. I can affect your will, what you want to do, or what you are on my statements, you don't do that thing. So I can affect your will. Okay. One, that is dominant position. Okay. Plus, using that dominant position, okay, one person is taking unfair advantage. So if I am in dominant position to you, and basically using that dominant position, I am taking unfair advantage against you, then beta, there is undue influence. Okay. Sir, how can be there dominant? Is there any example? Yes, I am telling example. Example, beta, if a person is in controlling position, Baba Gurus, they control your mind. Using that, okay, people trust them blindly. Using that, beta, if they make beta, they take unfair advantage of these devotees. Okay, so that is undue influence. Higher position, teacher. Okay, I'm the teacher of your college. I like your bike. I tell, okay, sell the bike to me for half price, or else I'm not going to clear you the exam. That is dominant position. You told yes. Position of trust, doctor patient. Okay, like example, beta, you came to me for you had stomach pain, hell lot stomach pain. Okay, and I know that if I give you injection for that, okay, you will be relieved. You also know injection cost is 300. I told sir 20,000. I know you will say 20,000. Yes, for that. Okay, so, because you are in immense pain. So basically, beta, am I in a dominant position? Am I taking unfair advantage of you? Yes. So basically, all these are beta dominant position, and using dominant position, we are taking unfair advantage. If it is the situation beta, then beta, that is undue influence. For undue influence, beta, what is the consequence of undue influence? Contract is voidable. Okay. In undue influence, which harm is required? Beta, mental harm is involved. Understood properly? Clear? Burden of proof is on the plaintiff. Like I am telling you, undue influence was exercised against me. I have to prove it. There was undue influence. Am I clear with this? Clear? Okay. Now, fraud. Now, fraud, section 17. Sir, if you did fraud with me and took a yes from my side, okay, so that is okay. Also a contract which is voidable. Now, but first, sir, what is fraud? The third, the 0 into 0, no, he hugs him. Okay. Now, so what is fraud? See, fraud means what? See, there is a definition of fraud also given. Huh? To do fraud and take a consent from me, take a contract is not valid, it is voidable. But what is fraud? See, I'm just reading assertion as to a fact by a person knowing it to be untrue, made with an intent to deceive the other party, by making him enter into contract whereby the party was damnified. Means I am giving a statement and I am telling that boss what I am telling is the fact, but I know it is not the fact, it is untrue. Why did I do this? So that the other person, you, should be cheated. You should enter into contract with me and you should be cheated. Deceive means cheat. Okay. and better you actually entered into contract and basically you were cheated and you were damnified. Damnified means you faced loss. Then basically I have done fraud. What does that mean, beta? Here a very important statement. Beta, if you want to sue me again for fraud, you should be facing losses. Am I clear with this thing? If you don't face loss, beta, then you cannot sue me for fraud. Like example, I purchased a property from you and I gave you a check. Okay. And basically, okay, I know that the check will be dishonored. I don't have money. You deposited the check, but at that time my income tax refund over the years came back and the check was passed. Can you sue me for fraud? No, obviously not. Am I clear? But if I have done fraud, so intentionally I did and you suffered losses, the consequence of fraud is contract is voidable because the other party can claim damages. Understood properly? Clear? Yes. Now there comes one question, beta. Sir, if I am entering into contract, I am selling you some goods and I know the goods are damaged, but I kept silent. I let you purchase. Will my silence be treated as fraud? Will silence be treated as fraud? Answer is no. Silence is not fraud except when it is the duty to speak and I did not speak, or where silence is as good as speech. Now like example, I am selling this phone, okay, to you. And basically example, there is a big crack on this phone. Big crack can be seen by visible eyes. But beta, like caveat emptor, I kept silent. I did not say, see, there is a crack. I did not say anything. You purchased it. Next day you are coming and telling I did a fraud. I did not tell you there is a big crack. Did I do fraud? No, because it was not my duty to speak. But in case, example, I am selling you a car and you told me, sir, I don't want an accidental car, and it was an accidental car. You told me, sir, if this is an accidental car, just let me know or keep mum. I kept mum. Okay, so here my silence is as good as speech. Boss, there is no accidental car here. This is not an accidental car. Am I clear? So then beta, my silence will be termed as fraud. Okay. But beta, there are certain contracts which are made on the basis of faith and trust. 5 contracts are there. In these contracts, it is told that if you as a party have some material information which will affect the contract, even though the other party did not ask anything, but if you have the knowledge of that, you should speak up. If you kept silent in these contracts because it is made on trust, then your silence will be considered as fraud. What are these contracts? However, in certain contracts, silence is termed as fraud. We call it as contracts abrime fide. What we call? Contracts abrime fide. That is contract made on utmost faith or trust. So which are these contracts? Let's understand. First is contract of insurance. Like if I take an insurance and basically fill a form, they write, are you drunkard, are you a smoker, this thing. I wrote everything, but there was no point question as, are you a diabetic? Example, I'm a diabetic and basically I did not mention it. So will it be treated as fraud? Yeah. I have to disclose everything. Now tomorrow if I die because of diabetics, will my family get the insurance money? Answer is no. Understood? Next, marriage contract. Sir, marriages are made on trust. So basically if you have any information which affects your marriage, you should disclose it, or else better it will be fraud. Like example, I am marrying a girl, but I'm a divorced person. I did not inform it. Example, I'm not. Okay, example I'm telling. I did not inform it to her. We got married. Okay, then later she understands. Can she cancel the marriage and claim fraud against me? Yes, obviously. Understood? Next, prospectus issued by company. Here, what the law tells, but whenever a company issues prospectus during public issue, company has to disclose everything which company knows. If there is important omission, that is company keeps silence on any fact, then better it will be treated as fraud, even though the investors did not ask. I'll give you an example. My company did a public issue. During that they issued prospectus and they wrote in the prospectus, company has a track record of paying dividend in the last 3 years and company paid dividend. But we did not mention that the company is paying dividend from reserves. Will it be fraud? Answer is yes. The reason is that beta, take a, why am I using reserves, past profits to pay dividend? Because this year I am not earning profit. So basically, is it an important omission? Yes. So here, company, by the company keeping silence here, okay, it is deemed that they are doing fraud. Okay. Next, family arrangements. Now, what is family arrangements? See, everyone trusts their family. Correct. For example, my dad passed away. Okay, and left two properties. So after my dad, my brother is there. I trust my brother, elder brother. So he did division of the property. Property A he will take, property B I will take. This is my brother's property. This is will go to Harsh. I did not check anything. Okay, because I trust. Later I understood that this property is already mortgaged to bank. So here, okay, I did not ask anything, but my brother knew all these things. Should he have disclosed it or not? Okay, can you say that the property papers so were there in the house only? Okay, you did not even check that. In that it is written mortgaged. I did not check because I trusted you, brother. Okay, so basically, okay, here my brother's silence will be treated as fraud. Next is any other fiduciary relation, like teacher student. I am taking lecture here. Now, YouTube students and basically you students, you trust the teachers. Now, example, there was some amendment, okay, which came in Companies Act, and I did not tell you the amendment because you did not ask. So if I did not tell you the amendment, you believe that there is no amendment because there is a fiduciary relation, and basically you wrote the papers, okay, without amendment and you fail. Can you sue me for fraud? Yes, because here my silence will be termed as fraud. Am I clear with this? Understood? Okay. So these are the contracts which we call as contracts abrime fide, where silence will be treated as fraud. Next, section 18, misrepresentation. Now sir, what is misrepresentation? See, there is a thin line of difference between fraud and misrepresentation, but the consequence is completely opposite. Sir, there are two types of misrepresentation. What do you mean by misrepresentation? To represent something in a wrong way. Okay. So if you do it willfully, you intentionally misrepresent things. So that is fraud, which we have done section 17. But one is innocent misrepresentation. Innocent misrepresentation means assertion as to a fact by a person believing it to be true. I am telling you something and I am telling it is true. Actually, it was not true, but I believed it to be true. That is what called as misrepresentation. Am I clear? Assertion as to a fact by a person believing it to be true. Like example, I am taking this lecture, but before coming to the lecture, okay, like especially in inter, I'll see ISA website. Is there any amendment? When I saw in the morning before starting lecture, there was no amendment. The students asked me, sir, is there any amendment? I told no. But actually, beta, during the lecture, some amendments came, which I was not aware of. Now I told no. So did I do fraud or misrepresentation? Misrepresentation. Okay, what I told, I believe it to be true. Am I clear? So here the contract is voidable, obviously, because the other party will be bearing loss. The other party can cancel the contract, but can he claim damages from me? Answer is no. Because did I do it intentionally? No. In fraud, I do it intentionally. So damages have to be paid by from my side. Am I clear? The contract is voidable, but damages cannot be claimed. Next is mistake. Now see, because of the four flaws, coercion, misrepresentation, undue influence, fraud, contract is voidable. But in mistake, contract will not be voidable. In some cases, it will be valid. In some cases, it will be void. Let's understand. Sir, mistake. We entered into contract on account of some mistake. A mistake is of two types. First, mistake of subject matter. Second, mistake of law. What do you mean by mistake of subject matter? It means better the things which we are buying and selling, we are mistaken as to that. And this can be unilateral mistake or bilateral mistake. What do you mean by unilateral mistake? Unilateral mistake means mistake from one party. And if there is mistake from one party, contract is valid. I'll give you example. But if it is bilateral mistake from both the parties, contract is void. Like, do you remember Chetak, horse Chetak, and basically that scooty Chetak? Both the parties were mistaken. So basically, that is bilateral contract. Contract will be void. Bilateral mistake, contract will be void. But unilateral, like example, Mr. Harsh is a seller. I'm selling cars. One day, Mr. X, he intended to buy white Varna car, which is diesel. Now I showed him Varna cars. Sir, you come and see the Varna cars. On the face of it, it was written on the windshield, this is A car, this is B car, this is petrol, and this is diesel. Now he wanted to buy diesel car, but A cars, petrol cars, interior were very clean. And he was checking that car and he decided to buy that car. I sold the car. Now, tell me, next day is telling you I did a fraud. Why? Like, I wanted a petrol car. I did not did a fraud. He's telling me I want to cancel a contract because there was a mistake. Okay? I wanted diesel car. Okay? I purchased petrol car. So it is of no use to me. Okay? Cancel the contract and give me diesel car. Okay? Will the contract be void or valid? Answer, it is valid. You selected the car. It is not my mistake. Okay? If there is mistake of from one party, the contract is valid. Am I clear? The next is mistake of law. What is mistake of law here? Sir, mistake of Indian law can be divided into two parts. Mistake of Indian law and mistake of foreign law. Like, tell me, it is assumed that law is a contract between me and the government, we and the government. Okay, so there are two parties to the contract, government, lawmakers, and we. So tell me, beta, example, okay, I know, you also know, beta, is hunting legal or illegal in India? It is illegal. For example, beta, one day while sleeping, the dogs were barking a lot. I took my gun and I started hunting them. Police caught me and I like, you are hunting, in India hunting is illegal. I'm like, sorry, I did not know. I never knew in India hunting is illegal. Can I give an excuse that I don't know Indian law? No. Hence that Indian law will be valid for me and basically I'll be punished. But beta, foreign law. If I go to a foreign country or a foreigner comes here, same thing. Like example, in Singapore, okay, chewing gums, like chewing gums are there. You cannot have chewing gums and you cannot sell chewing gums. Okay, many of you might not know. Even I did not know earlier. For example, I had a lot of chewing gums in my bag. So what to do? Okay, I started selling it on Singapore streets. They caught me. So can I say? And they told me it is illegal in here. Can I tell you, Are sir, I am from India. I did not know that your law punishes selling chewing gums. So basically, please treat this law void for me for the first time. Answer is yes. So mistake of foreign law, that law will be void. And mistake of Indian law, law will be valid and I'll be punished. Am I clear with this? Understood? Clear? That is the whole part. So we have finished beta. Take a free consent and capacity to contract. If you understood everything, give me a thumbs up quickly. Yes, good. The next, okay, unlawful object and consideration. Now, what is this unlawful object and consideration? Let's understand. Sir, we studied that the purpose of the contract should be lawful, consideration should also be lawful. If it is unlawful, beta, okay, then basically the agreement is void. We know this thing. So, sir, when can I say that there is an agreement with unlawful object and consideration and it will be void? So, these are the instances given. So, see, agreement forbidden by law. If there is an agreement which is punishable by law, Will it be lawful or unlawful? Unlawful. It will be void. Example, cutting trees without permission. Try to cut trees without permission of municipal authorities in Bangalore. See what will happen. That is punishable by law. Okay, that is void. Next, agreement defeating the provisions of an act. Like, I told you adoption is legal in India, but beta there is a procedure, na? Can I give donation to a orphanage center and I tell you I have to fly to USA? Okay, I'll just adopt any child, okay, and go. Obviously not. That is also void. Okay. Next, agreement to cause injury to property of another. I told you an agreement to murder someone, kill someone, or destroy someone's property. That is void, obviously. Next, immoral consideration. Now, what is immoral consideration? See, immoral and illegal, these are two different things. If you do an illegal thing, you will be punished by court, by police. But if you do something immoral, so you will not be punished. I'll give you an example. But if you enter into an agreement which has immoral consideration, that agreement is void. Okay, it's not a valid contract. See, example, Mr. X and Mr. Y are brothers. Mr. X is a very cunning person. He doesn't want to share his dad's property with Y. So what he decided, that Mr. X will push Mr. Y in the river and he dies, so obviously he'll get the whole property. Now he actually pushes Mr. Y into river and Mr. Y is drowning. Now I saw that. I was about to better jump and help him. Mr. X told, "Arey, why are you doing all this thing? Do one thing, I'll give you 5 lakh rupees. Don't jump, go away." I took 5 lakhs, but I was going away, but I was seeing why drowning. Okay, I was like, no, yaar, this is wrong. Okay, so basically, this is an immoral agreement between us. But like, no, this is wrong. Okay, my morality came out. Basically, I jumped in the water and saved Y. And Mr. X sue me. There was a contract, you committed a breach of contract. No, by saving Y. No, there is no contract between us. There was an immoral consideration not to save this guy. Okay, so obviously, beta, it is void. So we don't have any contract only. Okay. Next, fraudulent act. Now, what is fraudulent act? If me and you enter into a contract that will do fraud with your father, he doesn't know property rates and all. So I will buy the property at less price and we'll share the benefits. So basically, we two people do a contract to do fraud with your dad. The agreement between us, is it lawful or unlawful? Unlawful. It is void. Am I clear with this? Same example is here. Clear, everyone? Yes? So see the case. I stay in US, but I had a land in Bangalore. And the minimum value of the land, market value of the land is 30 lakhs. But I appointed Manan an agent to sell my land. Now, beta, Sudhit is a guy who understood the fact. He told Manan, do one thing, tell Mr. Harsh the value of the land is 20 lakhs. Sudhit will buy the land and basically take a 5 lakh rupees profit for both Sudhit and Manan. Okay, we will sell the land, they'll get 30 lakhs. The 5 lakh rupees Sudhit will take, 5 lakh rupees Manan will take extra. So there is an agreement between these two parties to do fraud with Harsh. So this agreement is void. Am I clear? Yes. Next, agreement opposed to public policy. If people enter into any agreement which is against public interest, those agreements are also void, beta. Which are these agreements? See, trading with alien enemy. India has entered into war with the country. I am doing contract with the citizens of this country. Is it valid or void? Void, no. It is against the public. Trafficking in public offices. Beta, that means selling public offices. I just give an example. I am retiring, home share gives me 1 crore, will get my government job. Is it valid? No, it is void. Interference with court of law and justice. Example, beta, somebody filed a case against me. I went to the judge and told, I'll pay you 1 crore, give the decision in my favor. I'm interfering in the court of law and justice. Basically, that is also void. That agreement is void. Now stifling prosecution. Stifling prosecution means affecting prosecution. Like affecting means agreeing not to sue. So understand this thing, what I have written. Stifling prosecution of a compoundable offense is valid, but of a non-compoundable offense is void. What is this? Understand, see. There are two types of offenses. Compoundable offenses, non-compoundable offenses. But a compoundable offenses are choto offenses. These are offenses where punishment is fine or imprisonment. Give fine or go to imprisonment. Example, traveling without ticket. Non-compoundable offense means a big offense where punishment is imprisonment or fine and imprisonment both. Example, murder. Clear? You come. Now, the example better, like if you're traveling without tickets, TC catches you, okay, and he tells pay fine. So what are you doing? You're compounding the offense. You're stifling prosecution. Because if he takes you to the court, court will tell you either pay fine or go to imprisonment. So TC is telling you the fine here only. So basically, is it valid? Yes. The stifling prosecution of a compoundable offense is valid, but non-compoundable offense is void. Like I saw example, I saw somebody committing murder of my relative, murdering my relative. Okay. Example, I saw somebody murdered my wife, and I saw that he also understood. And he's like, sorry sir, I came for robbery and your wife saw me, so I murdered her. Okay, but I can't murder you because I know I'm very weak, you are strong, I can't murder you, but please don't sue me in the court of law. Okay, I'm ready to pay 1 crore rupees to you. Like what? She's like, sir, I'm ready to pay 5 crore rupees to you. I told you murdered my wife and you are telling me 5 crore rupees and I should not sue you. Are you insane? Okay, at least 10 crore rupees. Yes. Basically, tell me, beta. Okay, I am agreeing not to sue him. This agreement between me and him, is it valid or void? Void. Because it is a non-compoundable offense, big offense. Okay, am I clear with this thing? Okay. Now, this is done. Next, beta, marriage brokerage contracts. Sir, one priest comes and tells, okay, you are a chartered accountant, tells your mother, okay, you want spouse for your mother only called that priest. I want spouse for my child. They're like, okay, I'll find it. No. I want a doctor spouse. Like my daughter is a chartered accountant and I want a doctor son-in-law. Or my son is a chartered accountant, I want doctor daughter-in-law. So priest tells, I'm the priest, okay, doctor spouse, you have to pay 15 lakhs, I'll arrange. Okay, 15 lakhs will pay. So basically, I'm acting as a broker for marriages. Is it in public interest or against? Against. We should not be brokers for marriages. That agreement is void. Okay, now you'll be like, sir, then so Shadi.com and all. They are not marriage brokers, they are marriage bureaus. Shadi.com doesn't tell you. Give us 10 lakh rupees, I'll find you a doctor bahu, I'll find you a doctor son-in-law. They just charge you money to maintain your portfolio because they are a software company. Okay, that is the reason. Next, interest against obligation. Now, what do you mean by interest against obligation? Like example, you are preferring money or favors rather than your job. Example, I'll tell you. See, you become auditor. Tomorrow you'll become auditor, and you came for audit taken in my company, and you found many things wrong. Now I also understood you will mention in the audit report, and then I have to answer to authorities and all. I will, sir, take 1 crore rupees and give a clean audit report. Now beta, you like 1 crore, no sir, 2 crore, sir, 3 crore final, chalo. 3 crore is just fine. Basically what you are doing beta, here, you are preferring your interest against your obligation. Your obligation is to give a clean audit report, but you are not doing it. So this agreement between me and you is void. Am I clear with this thing? Okay. Next, agreement for creating monopolies. What is monopoly? See, understand monopoly. Monopoly means single seller, large number of buyers. It is in favor of public or against? Against the public. So, example, Airtel and Jio, they big giants of telecommunication industry. They make an agreement that Jio will supply services in North India. Airtel cannot. And Airtel will do it in South India. Jio cannot do. So basically they're creating monopoly in North and South. Is it in favor of public or against public? Against public. So this agreement is valid or void? Void. Am I clear with this thing? Will they then they'll charge any prices they want? Correct? No? Simple. Okay. Next is maintenance and champati. Now maintenance and champati na beta, okay, it is told that there is a line. Maintenance and champati agreement are valid if they are reasonable, if terms are reasonable, or else it is void. Okay, so I'll give you examples of maintenance and champati. Okay, what is maintenance first? Maintenance is promotion of litigation by a person in a matter where he is not interested. Where he is not interested. Okay. Now, what is this thing? Let's take an example. Like Mr. Harsh is there. I'll not take this example, one new example. Miss, okay, Anandi is there. Okay. Now, I know Anandi, okay, is a person who has lot of reputation. She doesn't like people. She doesn't like better defamation. Understood? She is like very particular about her image. Now, understand. There is a person T, Tarun. Now, Harshna, I want to trouble Anandi. I want to defame her image. Okay. I want to defame her image. Okay. So she has many properties and all. Okay. So I want Tarun, okay, as a lawyer, okay, to file a suit, file an application plaint against Anandi's properties. Okay, so that beta, okay, I'll tell you these are Benami properties and all, okay, and I'll pay 5 lakh rupees to Tarun. Now Tarun tells, okay, I'll do this, okay, but tell me, is Tarun interested in that matter, subject matter? Does he have to do anything with Anandi and Harsh as such? No. But basically, this is an agreement to defame Anandi. Okay, so what will happen now? Basically, if we file a case that these are Benami properties, for some time, the government will come and basically they will seal the properties, and basically this will affect Anandi's image. For that, I'll pay 5 lakh rupees. Is it correct or it is not? Is it in favor of public or against public? It is not correct, no. So this agreement between me and Tarun is called as maintenance agreement. Am I clear with this thing? Okay, where we enter into an agreement, ticket to file, where one person, Tarun, promotes litigation in a matter where he is not interested, not at all interested, to defame other people. Okay, that agreement is void. Am I clear with this thing? Am I clear? That is maintenance agreement. Okay, now what is champati? See, champati also similar, but one thin line of difference is there. Champati basically means it is an agreement, okay, between, it is also promotion of litigation by a person in a matter, okay, where he is not interested, but in order to divide the proceeds of the issue, proceeds of the case. I'll give you an example of this. See, example, Mr. Harsh is there and Mr. A is there. Mr. Anandi and Harsh, okay, Anandi is staying in a property of 10 crore, okay, and basically there is a litigation. Chalo, not Anandi, chalo, I'll put it like this. Harsh is staying in a property of 10 crore. And one day Anandi comes and claims that it is her property. It is her property. And she is fighting, she has put a case. Now Harsh has to file a cross suit. But Harsh doesn't have now money to bear legal expenses. This property came by inheritance. So what happens? Okay, these people are fighting, okay, outside the court. Now there is a guy Tarun. He is listening to all these things. Now once Anandi leaves, na Tarun tells Harsh, ki, "Arey sir, you will win the case. You file a suit against her." So Harsh is like, "Sir, I don't have money." So he's like, "You appoint me, na my fees is 5 lakh rupees only." So he's like, Harsh is like, "Arey, I don't have 5 lakhs also." So he's like, "Okay, we'll do one thing. I will file a case on Anandi. I'll file a cross suit. Is he interested in that matter? No. But sir, if you lost the case, no problem. But if you win the case, then 50% of the property, okay, will go to whom, beta? To Tarun. Okay. So basically now tell me, beta, Tarun, okay, is promoting litigation in a matter where he is not interested in order to divide the proceeds of the case. That is called as champerty agreement. Will it be valid or void? Answer: if it is reasonable, then it is valid. Okay, like tell me, beta, his fees is 5 lakhs. Instead of 5 lakhs, beta, he is getting 5 crores ka property. Is it reasonable? No. So basically, tomorrow if Harsh doesn't pay, give him half of the property. Tarun cannot sue for 5 crores. Am I clear with this thing? Okay, court will say it's a champerty agreement and it is not reasonable. So it will be void. Am I clear with this thing? I'll take example of maintenance. In maintenance, beta, okay, this is one example. Maintenance, another example I'll give you. The Harsh and Anandi, they are having a legal issue. Anandi files a suit on Harsh here. Harsh doesn't have money to fight a case. But it is a matter where if Harsh wins the matter, he'll get a benefit of 1 crore. Tarun is listening to all these things. Now, Tarun tells Harsh, sir, you file a case, you will win. You appoint me as a lawyer. My fees is 1 lakh only. I told her, I don't have money. So what he tells, sir, okay, I will file a cross suit on Anandi. And if you lose, fine. But if you win the case, then basically you have to pay me 10 lakh rupees instead of 1 lakh rupees. So tell me, beta, take it here also, beta, Tarun is promoting litigation in a matter where he is not interested. Yes or no? Okay, but is it valid? Answer is yes, if the terms are reasonable. Tell me, beta, taking 10 lakh rupees in place of 1 lakh rupees, is it reasonable? No. Tomorrow if Harsh doesn't pay, beta, 10 lakh fees, beta, can Tarun file a suit for 10 lakhs? No. What will be saying? It is a maintenance agreement. You instituted a suit in a matter where you are not interested. And now you are asking unreasonable things. No, not allowed. Am I clear with this? Did you understand? So the difference in maintenance and champerty is that champerty is also kind of maintenance, but the purpose is to divide the benefits out of the case. Whatever the benefits you will get, okay, you will be dividing it. Maintenance, you don't have to divide the benefits. Am I clear? Your purpose is something else. If you understood, give me a thumbs up quickly. Understood properly? Very good. Okay. Now, so these were the agreements which were against public policy and unlawful, and that's the reason it was void. Now, the last one. We have finished better capacity to contract. We have finished unlawful object and consideration. We have finished free consent. Okay. Now, the last one, agreements expressly declared void. So there are some agreements which are expressly declared void by the law. So me and you cannot enter into this agreement. It will be void as such completely. So which are these? See, first, agreement in restraint of marriage. I cannot enter into a contract with you, okay, and tell you I'll pay 5 lakhs, stop the marriage of this guy, or I'll pay you 10 lakhs, you don't get married, or basically I'll give you 10 lakhs, stop my marriage. No, agreement to stop your marriage is also void. Okay, but exceptions are there. Minors marriage, you can pay 5 lakh rupees ticket to some Mr. X to stop the marriage of a minor. Yes, that is okay. That's no problem because minors marriage are not allowed only. Okay, that is section 26. Next, agreement in restraint of trade. What is this agreement in restraint of trade? Understand properly. Guys, see, in India, which is the biggest or the prime law in India, Constitution of India. Correct? Now, as per the Constitution of India, there are certain fundamental rights given to us, which not even Supreme Courts can take away from us. And basically, can we and you enter into any contract which is against the Constitution? No. So one of the fundamental rights which is given in the Constitution is freedom to carry on any business, trade or occupation. Nobody can stop. So can me and you enter into contract where I'll say you give me this much money, I will not do this business? Answer is no. Okay, that is void agreement. You cannot enter into an agreement to stop the business of someone or to tell someone you don't do this thing. No, you can't do this business, not allowed. But beta, there are exceptions. There are exceptions to the same also. In these situations, okay, one party is restraining the other party, stopping the other party from doing a particular business. Okay, that is valid. Now, which are these cases? First, sale of goodwill. What is written, beta? Buyer can restrain seller of goodwill from doing business within a given area or for a particular time. Okay. Now see, what is this example? Example, I am running a business of sandwich making. So basically I have a stall, fresh sandwich. One day, and my daily income is 1 lakh rupees. Okay. One day, Mr. X comes and tells, I want to buy this business along with the goodwill, I'll pay you 1 crore rupees. Chalo. So he's the buyer of goodwill. So what I told, okay, I'll sell it, no problem. But he has put a clause. What is the clause? That once I buy the goodwill, you cannot do same business within 2 kilometers radius or for 2 years. Is it a valid? Here see, he is restraining me from doing business. Is it valid? Answer is yes. The reason is that beta, okay, the reason is that when he paid 1 crore rupees, maybe beta, out of that 1 crore, 50 lakh is for goodwill only. 50 lakh is my physical asset, 50 lakh is goodwill. So basically, in case that goodwill is basically because he wants ready clients. Tomorrow beta, if this point is void, then beta, I will start another business, like same business next to him, and I'll write her sandwich. And my clients will come to me only. I'll stand outside. Okay, I stand outside like this. Yes or no? Outside the store. So basically, what is the use of he paying me 1 crore rupees? Understood? That's the reason, but it is valid. Am I clear with this? The buyer can restrain seller of goodwill from doing business within a given area or for a particular time. Am I clear? That is valid. But if he tells you cannot do business anywhere in India, okay, or never, you cannot do this business ever, so that is not valid. Okay. Next is negative service agreement. Now, what is negative service agreement? Like it happens beta. Okay. Like example, I joined a classes. Harshendra joined the classes. Okay. And we had a contract of 5 years. Okay. And in that contract, it is written that till the time I am teaching in these classes, okay, for that 5 years, I cannot join any other classes. Another classes I cannot go. Is it valid? Answer is yes, it is valid. Because this classes is giving me a lot of workload, good money. Why? Because he wants the best faculties here. So basically, if I am going somewhere else, what is the use of he giving me that much money? Did you understand? Okay. Next. Partnership agreement. Sir, example, me and you enter into partnership. Can we write that was until we are partners? Okay. No partner should carry on competitive business. Answer is yes. Can do this. Or similarly, if A, B and C are partners, they enter into an agreement that during partnership, and even example, if C leaves the partnership, he retires, within 2 kilometers or for 2 years, he cannot carry on same business. Is it valid? Yes, that is also valid. Am I clear with this? Understood? Next is trade combinations. Now what is trade combinations? Understand. Example, Harsh, Aman and Tarun, we are wholesalers of sugar. See the example, it's a good example. What happens? We buy sugar, we are from Mumbai and we buy sugar from wholesaler. Like we buy sugar from manufacturers. Okay, we are wholesalers. So there are two options from whom we can buy sugar. One is Farhan from Mumbai, one Nikita from Gujarat. If you ask any person, they'll say, yes sir, you should buy from Mumbai because transportation cost and all is less. Correct. So everyone is buying from Farhan. Now Nikita called me and she's like, I also started business, buy from me. So I asked her one question. You tell me what is the production capacity of, and she's giving me discount also. Okay. I asked her what is the production capacity of your factory. She told me we can produce 10,000 kgs of sugar every day. And I was thinking I need sugar. Like my truck's capacity is also 10,000 kg. And transportation cost, okay, from Mumbai to Gujarat, through and fro is 10,000. Okay, that truck's fuel expenses. So if I spend 10,000 rupees for 10,000 kg rice, per kg transportation cost is 1 rupee per kg. So I told her, do one thing, I'll buy from you. But condition is that you have to sell your entire production to me. You can't sell it to anyone else. So tell me, am I restraining her from selling the goods to someone else? Yes or no? I'm stopping her from doing business with someone else. Yes. Is it valid? Answer is yes. Because if this is not valid, tomorrow if she sells out of 10,000 kgs, 5,000 kgs to someone else, I go and I get better only 5,000 kgs. My transportation cost is 10,000. So rupees 2 per kg is my transportation cost. So that's a loss for me. Basically, this restraint is valid. Am I clear with this? Understood? Good. Next, agreement in restraint of legal proceedings. Now, what is this? Let's understand. Sir, again, it's your fundamental right to file a case on people, on people who commit a breach of contract with you. Nobody can take this right. So, example, A and B enter into contract, and they write in the contract that if A, tell me, forget about A and B, like you and me enter into contract, and we write in the contract that we'll do business, and if you commit a breach of contract, I'll sue you. Is it correct here? If I don't commit a contract, okay, you will sue me. Is it correct? Can I write if I commit a breach of contract, I don't fulfill the contract, okay, then you cannot sue me. Can I write it like that? Can we write ki in case either of the parties don't fulfill the contract, okay, so basically none of them can file a suit on each other? No. Filing a suit on other party who's committing breach, it's your fundamental right. You can't basically write anything that we will not sue. No. The complete restraint of legal proceeding is void. But partial restraint is valid. Now what is partial restraint? Example, okay, me and you stay in Mumbai. A and B are B people. But contract took place in Bangalore. Now generally beta, where the contract takes place, where there we have to file a case. But we have both entered into a contract that boss, in case any dispute happens, we'll file a court case in Mumbai court only, not Bangalore court. Is it okay? Yes. That is partial restraint. That is allowed. Am I clear with this? Second, arbitration. Now what is arbitration? Okay, arbitration means outside the court settlement in arbitration councils. Their number of cases are less. If you file case in normal courts, already 3 crore pending cases. Basically, there will be delay in getting justice. So we decide that we will not go to courts, but we will go to arbitration councils. Is it okay? Yes. Answer is okay. No problem. Am I clear with this? Yes. Next, agreements, terms of which is uncertain. We studied this thing earlier only. Terms of agreement must be certain, or else it will be a void contract. Yes or no? Okay. Basically, that is already done. Okay. Now, one last point is of wagering agreement. Okay. We'll do this wagering, but first we'll take 2 minutes break and then we will start wagering. Okay. This part is important. Okay. You can't leave it. Unit 3, they ask question. Wagering will do it. Okay. Short and sweet will keep wagering, but 2 minutes break, then we'll do it. Not heavy, but it is bit lengthy. Okay. So, chal. Now, let's understand what is wagering agreement. Let's see. But a wagering means what? But a betting agreement. Okay. A tells B that it will rain. B tells no, it will not rain. A tells if it rains, okay, B will pay 100 rupees to A. But if it doesn't rain, A will pay 100 rupees. So what is this beta? Betting agreement. It's an agreement where parties promise to pay money or money's worth on the happening or non-happening of a future uncertain event. That is called as wagering agreement. Is it valid or void? Answer beta, it is void in all the states except Maharashtra and Gujarat, because in Maharashtra and Gujarat it is illegal also. Am I clear with the same? Now, it is an agreement where parties promise to pay money or money's worth on the happening of an uncertain event. Now, there are some characteristics of wagering. In wagering, beta, only difference amount is settled. What do you mean by that? Only difference amount is settled. It means, like example, India versus Pakistan match is there, and basically everyone is like India will win. We know that. So basically, in betting, 1:5 rate is going on. If I put 1 lakh rupees, and if I am putting on Pakistan, and if Pakistan wins, so basically I'll get 5 lakhs. Understood? Like that. So basically, tell me, example, I called the bookie and I'm like 1 lakh rupees on my side. And example, Pakistan won. I was playing for Pakistan. So basically, tell me, I will win how much? 5 lakhs. So tell me, will I give 1 lakh and take 5 lakhs? Or I'll directly take the difference? I'll directly take the difference, 4 lakhs. That is called as wagering agreement. The only difference amount is settled. In wager, one party's loss is other party's gain. One party's loss is other party's gain. Okay, if it rains, okay, then basically it's a profit of 100 rupees for A. Consequently, it is a loss of B. Simple. These are the essentials of wager. Am I clear with this thing? Okay. Now we'll do some reading of wager. Wagering, we have to do bit of reading. There is an agreement involving payment of sum of money upon the determination of an uncertain event. The essence of wager is that each side should stand to win or lose, depending on the way an uncertain event takes. Example, A agrees to pay 50,000 to B if it rains, and B promises to pay like amount to A if it does not rain. The agreement will be by way of wager. Wagering agreements are void, but collateral to wagering are valid. It is basically in other state. Illegal agreements are void, and collateral to illegal agreements are void. That is basically for Mumbai and Gujarat. Essentials of wager. There must be promise to pay money or money's worth. Parties must be conditional. Promise must be conditional on event happening or non-happening. Either it will rain, it will not rain. There must be uncertainty of event. Yes. Okay. It might happen, it might not happen. There must be two parties. Each party must stand to win or loss. Okay. One party is gaining, another party is loss. There must be common intention to bet at the time of making such agreement. Purpose is betting only. Parties should have no interest in the event except for stake. Means they should be concerned only for money. Apart from money, like example, India, even being an Indian, I am concerned that beta Pakistan should win. Basically my purpose is only gaining money, no other personal interest. Now lottery transaction. Now beta in wagering na there is a good line. Okay, game of chance is wager. Means if you win by chance, it is wager. But game of skill is not wager. So basically tell me lottery transaction, it is game of chance or game of skill? Game of chance. So lottery is wager. Even if it is authorized by government, it is wager. Am I clear with this thing? As per Indian Contract Act. Crossword puzzles and competition. But crosswords, puzzles are game of chance or game of skills? They are game of chance or game of skills. It is game of skills. It is not wager. Okay, but example. Any element of chance is there now. If there is any element of chance involved, small element of chance is involved, then beta it will be wager. Like example, if there is a newspaper and in the newspaper the editor has given a puzzle like PRTA and he's telling question, make one 4-letter words and two 3-letter words. Okay. Now if I give the answer, part is there, trap is there. Okay. Then basically 3-letter rat, tap, pat, art. Now beta example I gave this answer. Okay, one 4-letter word and two 3-letter words. And if I win it, it is game of skill, it is not wager. But what the editor mentions na, he has his answer. See, this is his answer. He has already made one answer. Part, rat, tap. Now if my answer and his answer matches, then only I'll get the prize. So it is game of chance or game of skill? Game of chance. Some element of chance is involved. So basically then it is not wager. Am I clear? Understood? So see, crossword puzzles in which prizes depend upon correspondence of the competitor solution with previously prepared solution kept with the editor of a newspaper. Okay, is a lottery and therefore a wagering transaction. Understood everyone? Yes? Then this point, this is as per Prize Competition Act. If I win the prize, if I win the crossword puzzle athletic competition, I'll get prize. Now as per Prize Competition Act 1955, if the prize amount does not exceed 1000, it is valid, no problem. Okay, but if it crosses 1000 better, then it will be wager. Okay, that was as per Prize Competition Act, not now. Okay, now it doesn't exist also. ICI does not remove it, I don't know why. State of Bombay versus RMD Chambar Bangwala. Same thing, but if my answer and editor's answer matches, then only I'll get the price. So that is wager. Next is speculative transaction. Now have you heard about beta futures and options? Future trading, option trading. Yes or no? Futures and option. Okay. So basically here people who know about futures and option, they know ki boss, in futures and option beta we don't do actual buying and selling of shares. We just settle the difference. Yes or no? So practically it is allowed, but as per Indian Contract Act, okay, that share market raise transaction where you are just settling the difference, that is wager. But practically it is allowed, but in question if it comes, okay, then you have to write it is wager. Am I clear with this thing? Next beta, horse race. You know, in Bombay, in Bangalore, there is horse racing competitions. Okay, you go and you put money on a horse. Okay, if the horse wins, better you will get a lot of money. Basically, that is also game of chance. It should be wager, but no. What government has told beta, okay, horse racing. Okay, if you put money on horse racing, okay, provided basically, okay, the minimum amount which you are betting should be 500 or more. Okay, so basically if you are putting 500 or more, okay, as bet money, so basically on a horse, so it is not wager. There are reasons. It is to save that breed of horses. Okay, am I clear? So basically beta, ठीक है, if horse racing, yes, is kind of wager. Okay, it is like betting only. If this horse wins, take I put money. If this horse wins, I'll get this much money. That is wager. But if the bet money is 500 or more, then it is not wager. Less than 500, it is wager. Am I clear? So a horse racing where price payable to the bet winner is less than 500, then it is wager. 500 or more, it is not wager. Practically, if you go, okay, for putting money on a horse race, on a particular horse, minimum amount which you will be putting beta will starting from beta 1000, 2000, 5000 and all. Okay, beta chit fund. You know, chit fund schemes are there. Chit funds, like 10 people come together, they put money 1,1,1,1,1,1,000. Okay, and basically one child will come, cheaty, he'll pick one, and basically everyone will put money, so total 10,000 is there, and there will be 10 cheats of individual name. One child will come and pick one cheat, the person whose name is there, he'll get that 10,000. Next time again every 10,000 corpus will be there, but there will be 9 cheats. The person who has won, his name will not be there. So that is chit fund. Will it be wager? No. Why, sir? Because in wager you'll be like, sir, here also it's a game of chance. Yes, but beta, one important characteristic was there of wager. One person's loss is other person's gain. Here nobody is going to lose beta. Ultimately everyone is going to get better than 1000. That is the reason. Contract of insurance. Beta, I took insurance for myself. Okay, and it was a term insurance, and in the insurance contract it is written that if I die, my wife will get 1 crore rupees. Just imagine, she knows it. Okay, so basically will it be wagering? No. The reason is that, but I told you, in wagering parties are concerned only with money. Tell me what my wife will, what my wife would want. I should die and she should get money, or I should not die and she should not get money. There is a, I should not die and she should not get money. Hopefully, I think that's the same thing. So she is not concerned only with money. So contract of insurance is not wager. Next, promissory note out of wagering. Example A, na? A told na it will rain, but it did not rain. A has to pay 100 rupees to B. A is like, I don't have money, but I am writing, I promise to pay B a sum of rupees 100 one day after date. Gives it to B and B will show it, and when A will pay. That promissory note, will it be valid? Answer is no. Because better that wagering transaction is void. Basically that promissory note is also be void. Am I clear with this? Understood? Clear? Everyone? I hope you understood. If you understood, give me a thumbs up quickly. If you understood. Yes? Good. So here your unit 3 came to an end. See, we are doing crash course, so that's the reason very in depth we are not going. Okay, we are just understanding the terms. Okay, it's kind of revision only. Okay, now okay, now we'll be doing unit 4. Let us understand. Unit 3 is done. Okay, 3 units we have finished. Starting with unit 4. Let's understand. Discharge of contract. See, I told you first 3 units talk about how a contract is formed. This unit will talk how a contract will come to an end. Now, beta, there are 5 methods how a contract will come to an end. First is by performance, then is by agreement, then is by impossibility, then is by operation of law, and then is breach of contract. Okay, so we'll first do operation of law, then we'll do agreement, then impossibility. Breach of contract is anyways unit 5. Okay, it will next unit it is, so we'll do in the next unit. So first is operation of law. Now what is operation of law? Understand. But a law tells that, boss, in case these things happen, then by default of law the contract will come to an end. What does this say? Unauthorized alteration in written contract. If me and you enter into a contract, okay, example, Harsh, I am the landlord, you are my tenant. We made an agreement, rent agreement, and the original copy was with me. Now without your consent I made changes in that contract. Is it against you or not? Yes. So there itself the contract comes to an end. Am I clear? Then merger of contracts. It means better smaller contracts get converted into a bigger contract. Okay. Like example, same thing. You are on rent. There was a rent agreement going on. But after some time, beta, you got this feeling that I should stay in this house forever. You decided to buy the house. So you offered to buy the house. I told, okay, no problem. I'll sell it. So that rent agreement got converted into sale agreement. Smaller contract got converted into bigger contract. There was bigger merger of rights, bigger rights you got. Basically, that rent agreement will be dissolved. Am I clear with this thing? Next, by insolvency of party. Me and you were entering into contract. We were having a good contract. But suddenly, beta, I became insolvent, was declared insolvent. Now, will you continue the contract with me? No, because I will not be able to pay off your liabilities. I will not be able to perform the contract. So basically, from that day itself, the contract will come to an end. Next, beta, by limitation period. Now, what is limitation period? Sir, do you remember that 3 years? I entered into contract with you and I committed breach of contract. You have to sue me within what time, beta? 3 years. If you don't sue me within 3 years, so basically the law tells you, boss, nothing wrong happened, no contract took place, contract by default gets discharged. That is by operation of law. So these are the 4 ways how a contract gets discharged by operation of law. Okay. Next, by impossibility. Okay. See, we studied beta. We studied an important thing. Sir, a contract get discharged by impossibility. What does that mean? Do you remember we studied beta? There should be possibility of performance in essential elements of valid contract. If performing the contract becomes impossible, will it be a valid contract? Answer is no. Basically, on the same principle, this point is made. Impossibility of performance, that is called as doctrine of frustration. Now, what does this point tell? See, sir, it is impossible to perform the contract. That is, there was impossibility to perform the contract. This impossibility may exist at the time of formation of contract. Okay, from the formation only it was impossible. Or second, there was supervening impossibility. Now, what do you mean by supervening impossibility? It means, okay, that at the time when the contract was formed, at that time it was possible to perform the contract, but later on, beta, due to change in circumstances, it became impossible. So basically, that is called as supervening impossibility. Like example, I told you, na, I promised to marry a person, example, okay, and that person also promised. Now, before marriage, that person died, so obviously it is subsequent impossibility. I appointed a person as a driver. From next month, come for driving. Okay, before that he died. Subsequent impossibility. What can we do? Am I clear? The contract is void. But beta, if the impossibility existed at the time of formation, okay, then there are 3 situations. First, the impossibility was not known to both the parties. Like example, Mr. A agreed to supply sugar to Mr. B. Contract took place today on 27th November. But beta, this supply is going to happen on 27th December. Okay. Neither me, neither him, neither A, neither B knew that boss, government has issued a notice that only government can supply sugar. Individuals cannot supply sugar. So basically, can it be performed? No, it is void agreement. Known to both parties. Like I told, I'll give me 1 crore rupees. I'll make a machine. From here you put potatoes, from there, okay, gold will come out. We know it is impossible. Then too, beta, we entered into that agreement. Is there any use of that agreement? No, it is void agreement. Third, known to one party. Like example, B came to A. Yeah, I want sugar on this day, 27 December. He came to me today, and he gave me a contract of 5 crore rupees ka sugar. And he's like, yeah, I'll give you advance now 1 crore. Now I knew that I cannot supply this sugar because government notification has already been issued. Then too I thought, "Kya 1 month, na, okay, you give me, sir, okay, I'll supply." I did not tell him because I wanted to use this 1 crore for my business purpose. Okay. And then beta, on 27th I'll say, oh sorry, government notice has come. I didn't even know, you also didn't know, I can't supply sugar, take your 1 crore back. This is kind of fraud, no? Okay. But beta, the agreement will be void. Now here people will say, sir, it should be voidable, na? It is void only, not voidable. The reason is that, beta, can I supply the sugar? No, it is not possible only. Okay, if it had been possible, then beta, it would be voidable. Here so I cannot supply only, no, now. So that is void agreement. Am I clear with this? Understood properly? Clear? Sir, here one important point I have written. In subsequent impossibility, impossibility should be permanent and temporary, and not temporary. Means what? Example, A entered into a contract with B that I'll supply you cotton, manufacture cotton and give it to you. But what happened now? In between beta, take A's workers went on strike. A told, sorry, the contract is void now. I can't perform the contract. It is impossible. So B, you can take your advance back. I can supply. Tell me, is it a permanent impossibility or temporary impossibility? Temporary, na? Strikes are temporary. Strike will be dissolved. Then better you can supply. Yes. So basically, it is not impossibility. Contract is not void. Am I clear with this thing? Contract is valid unless otherwise agreed. If in the agreement it is written that, boss, I want cotton very quickly. If there is strike, okay, in your factory, then the contract will be void. Then beta, it will be void. Okay. Sure. Next. Now this question came in the exam. What is this question? Let's understand. This question states, state the circumstances under which contract need not be performed with the consent of both the parties. So basically state the situations where with the consent of both the parties contract gets discharged. Both the parties give consent and basically they'll be like, okay, we will not perform the contract. The contract will be discharged. 7 marks question came. So there are 5 situations. First is, okay, by novation. Second is alteration. Third is rescission. Fourth is remission. Fifth is waiver. First 3 are section 62. Last 2 are beta section 63. So in case this any of these 5 things happen, the contract get discharged with the consent of both the parties. First, by agreement. In that first, novation. Novation means what, beta? Cancellation of old contract and making a new contract. That is called as novation. So basically, what happens in novation, beta? In novation, beta, or maybe parties to the contract may change. So cancellation of old contract and making a new contract. So basically, tell me, beta, once the new contract is made, will the old contract be performed? Answer is no. We have an example of this. See, A and B, they are partners. They took loan from D today, 27 November. Okay, so they are liable. Later, Mr. C was admitted on 27 December. Okay, is he liable for this debt? No. But in case he agrees, then he is liable. Okay, he agreed with whom, beta? He agreed with A and B. I don't have that much capital, but I will participate in this loan also. Basically, A and B told, okay. Now, tomorrow on the due date, example, beta, this loan is not paid to D. Can D sue A, B and C? Answer is, beta, no. He can sue only A and B. But sir, C agreed na. C agreed with whom, beta? A and B, not with D. D is a stranger to contract. Make clear with this. But example, if they make a new contract, A, B, C, taking loan from D. So basically now, beta, can D sue C? Answer is yes. This is novation. Cancellation of old contract and making a new contract. Now, beta, see, parties to the contract change. C was added. Make clear with this. Understood? Good. Next is alteration. What do you mean by alteration? making important changes in the contract, in the terms of contract. Like example, A took a loan from B, rate of interest was 10%. Later beta, they mutually decided to change the rate of interest from 10 to 9 or 10 to 11. Basically it is important terms na, interest is the most important term in loan. So that is called as alteration. In alteration beta, parties shall not differ. It is the same parties na A and B. Okay, only terms will change. Am I clear with this? That is alteration. So now beta, they will follow 10% clause or the new interest clause. New interest clause. Next is by rescission. Now what is rescission beta? Mutual cancellation of contract. Okay, like example beta, simple example, classic example of that is mutual divorce. Okay, we both don't want to continue the contract. Marriage is a contract. Tata goodbye, simple. Next is by remission. Now what is remission beta? Accepting a less consideration than that was promised. I'll take an example of this. Yes. इसका example, classic example is credit cards. A swiped credit card, okay, of 1 lakh. Now he has to pay to the bank. Now generally they will not pay. So basically bank people come, talk good things to with A. Ultimately A tells you I'll pay only 60,000, I don't have money. Bank will pay and say no, you have to pay at least 90. Then they'll mutually come to 75,000. Now A will pay 75,000 and basically it will be like, okay, he has paid 1 lakh rupees. Okay, the contract get discharged. Basically what was the actual amount due beta? 1 lakh. But basically now bank accepted a lesser consideration than that was paid. Because there is no use of filing a suit on him. He doesn't have anything. That is called as remission. Later on can bank sue for 25,000? No. Now you will be like, sir, then everyone should do this thing only. No re beta. If you do this thing, then your CIBIL rating will fall down. Okay. And for next 2 years, you will not going to get any loan. That is the point. Understood? Next is waiver. Now what is waiver beta? Party gives up his right on the contract. I don't want my rights, fine, no problem. Okay, let it be. Am I clear with this thing? Like I'll give you example just for understanding. I purchase some ice cream from a shop. Okay, and 80 rupees was the ice cream cost. I gave 100 rupees. Now my relatives came, and basically in front of relatives I told ki just to show off, he was paying 20 rupees. I'm like, no, keep the change. Okay, am I clear with this thing? So this is my right. Okay, but what I did, I waived off my right. It was my right to take 20 rupees and keep the change. He's like, sir, 20 rupees, keep the change. Relatives are like, wow, rich people. And when relatives went, I'm like, hey, give me the money. Can I tell him to give the money? No. Because obviously, beta, take it, there is waiver. This is just for understanding. Am I clear with this thing? I'll give you an actual example. Like example, Mr. A and B is the husband, B is the wife. They went into divorce. Now in the divorce, court told A has to pay 1 crore rupees to B and signed it. So now it's a contract. Now A told B, okay, I'll give you 1 crore rupees, but I wanted you. Maybe it is my mistake, but don't worry. If you want more than 1 crore, you tell me, I'll give it to you. Now B told ki, I wanted you to realize your mistake. I don't want your money. A is like, take the money. But then no, let's go to the judge. They went in judge's cabin and B told, I don't want this 1 crore. Judge is like, are you sure? But yes. Now okay. He wrote again no alimony and told both of them to sign. Now beta, both of them signed. B left. Now he is like, thank God. Okay, I don't have to pay 1 crore now. Basically beta, she had a right to take 1 crore. But now beta, does she have the right? No. She herself told Tata goodbye to the right. Am I clear with this thing? Understood properly? That is what beta? That is nothing but waiver. So basically, if you get a question, state the circumstances where a contract gets discharged with the consent of both the parties. Answer is novation, alteration, remission, rescission. Am I clear? Yes. So you understood everything up till now? If you understood, give me a thumbs up quickly. Good. Okay. That's it for the day, guys. Okay, stopping here. Bye bye. Take care. Remission means accepting a less consideration. You had to pay me 100 rupees, but you did not have 100. You had only 80 rupees. Okay, I am like, okay, no problem. You give me only 80. We signed the contract for 80 rupees then. Okay, that is remission. Now can I claim 20 rupees from you? Understood properly? Chalo, bye bye. Take care. Bye. Tomorrow we'll finish this lesson and we'll start with special contracts.